All right, my friend, Mr. Mike, I believe we are live on YouTube and also on at least one Facebook group. So, uh,
Super.
welcome to this little fun way to start July, talking about all sorts of consumer issues, but particularly about those lovely folks at Midland and Portfolio and LVMV that like to sue consumers. So, tell me what's been going on in your world.
Well, it's been really interesting here because the courts are starting to reopen kind of in full force. There's still a bunch of remote online hearings that are still scheduled and going forward that way. But the judges I've been hearing have been talking about, returning to open court. I've got a foreclosure trial coming up on August 3rd that looks like it's going to be live and in person, which will be the first time I'll have been inside a courtroom since March of 2020.
Oh, wow.
Everything else I've been doing has been remote, and had a couple Zoom trials the last month on foreclosure cases and things like that. So it's been kind of this pendulum swing back from the doldrums of the pandemic, where nothing was going on or a lot of things were on hold, and now we're kind of getting back to normal, the best we can define that. And I'm not sure what it's going to look like totally, but it's definitely some things are changing back. So
yeah.
what you're seeing?
Yeah. So in Alabama, it really varied by county. I mean, I was doing in-person trials, fall of last year. And, but then there are some counties that are still pretty much all remote. And, but yeah, things are getting back to normal. And,
some counties are more remote than others.
Yeah. And you can imagine, I'm sure it's this way in Florida where you practice, all these cases kind of get jammed up and the judges are like, we got to get these things moving. And so we're starting to get lots of trial dates. And look, you and I have known each other for a few years, and but let me take a step back and introduce you for those who are watching who don't know you. So Mike and I met a couple years ago. And Mike is a consumer protection lawyer in Florida. I do the same thing in Alabama. And we thought, well, this might be a nice way to answer questions. So those of you who are watching, I see we have a good number of people on YouTube. And, feel free to put in comments. And assuming those show up, which we believe they will, we will definitely do our best to give you not just one answer, but two answers maybe. And because there are differences in Alabama and Florida. So, Mike, if you'll give everybody kind of a quick background on yourself and what type of law you practice.
Sure thing. I have been practicing for more than 25 years now. I was first admitted in Florida in 1995 after graduating from the Florida State University College of Law. Go Noles. And basically since about...
I don't think we allow that on this show, do we?
Oh, okay. Well, we won't get too partisan about our sports teams, but Jason and I, my partner Jason Ricardo and I, started this firm in March of 2005, and so we've been doing this for over 15 years, and most of what we have done throughout the life of the firm has been some kind of consumer representation, some flavor of debt defense or foreclosure defense. And I'd say probably most of the lifetime of the firm, we've been representing individuals against kind of the bigger, badder, more powerful entities that are coming down on them. And so that's kind of what we enjoy doing. And we've been doing that now for years, and we like to think we're getting good at it. So,
well, it's funny. I didn't know the exact dates there, but I started practicing in 95. And my law partner, Stan Herring, and I, we started working together in 06. So I didn't realize there were such similarities there. But let's see, Mike, it looks like we've got let's see, CR says, hi, Mike and John. So, hey, good to see you. Thanks for being on here. And just let us know if you have any questions or anything we can answer for you. And let's see, Tony, thank you so much. You are very welcome. Good to see you, Tony. And let's see.
I am seeing one question. There we go. You found it.
Yeah. Okay. Yeah. So Albert Revere says, my question is, Experian keeps reporting on a CF as derogatory delinquent late payments. I've tried and tried for them to correct it, but no luck. What do you recommend? So I guess, Albert, if you don't mind, let me make sure that we understand what you mean by C/F. And so I think I know what you mean, but let me know about that, and we'll come back to you on that and definitely answer. So here's Cedric. Cedric's a great guy who helps a lot of people with credit repair. And so Cedric's question, if you have multiple violations on an account number, is the civil liability payout to the consumer still $1,000 no matter how many violations under an account number? So that's a great question, Cedric. If we can, let's take a step back. So if we're talking about the FDCPA, so Fair Debt Collection Practices Act, it really is just $1,000 in statutory damages. So statutory damages are where we cannot prove we've actually been injured. But we can always, assuming we can prove we've been injured, maybe emotionally, economically, we can get more than the $1,000. Now, if we're talking about the FCRA, Fair Credit Reporting Act, we get the up to $1,000 statutory damages if we can prove it's willful. And there's kind of a difference of opinion. Maybe that's only $1,000, or maybe it's multiple. Question I have for you, Mike. You guys have a very cool little statute there in Florida that's kind of like the FDCPA, but state law, and it applies to original creditors.
Right.
What's the deal with that on the $1,000? Do you know?
As far as statutory damages, and I do want to reiterate one thing you said, which is if there are actual economic damages, something has cost you out of pocket, or something has caused you substantial emotional stress, and maybe you're seeing a doctor because of the stress you're suffering from this one thing and can prove that, that's not subject to $1,000 cap. But the FDCPA, which is the federal statute, has that $1,000 statutory damages, which you can claim once in the case, no matter how many violations there are. And then under Florida's similar statute, there is also a $1,000 cap. And it once Florida's statute was recently changed a few years back to clarify that it's $1,000 in one lawsuit, no matter how many violations. But what's cool about those is that if there's a federal violation and a state violation, you can stack them. So it'd be $1,000 for one and then $1,000 for the second one. And in some cases, depending on where the debt collector is, if I've got a Florida client being harassed by a California debt collector, for example, I have in the past alleged successfully violations of the federal, the Florida, and the California statute. And so all three damages would stack there. So just depending on who's doing the violating and where, each individual statute is going to have that $1,000. But if you know how to get the foot in the door with a different statute, then you might be able to, stack up that $1,000 on top of another $1,000 and so on.
Yeah. And Cedric, just to follow up on that, a lot of states don't have a good state law version of the FDCPA, for example, but some do. And so it's definitely worth checking out. In Alabama, if I have a debt collector harassing me, there are some state laws that I can use, but we only sort of have one gun of the FDCPA. In Florida, they're coming.
We're Yosemite Sam. Boo, boo, boo.
Yeah, gunslinger there. So, but great question. And let me see here. So here's a question. What's your take on the free credit repair site Creditversia? So I am not familiar with that. I'll tell you this, on anything that is, free, you're smart to always ask, well, what's the catch? How are people making money? And it could be that they get you to sign up for credit monitoring. Maybe that's $30 a month, and they're making $15 or $20 a month on that. I'll tell you this, and Mike does the same thing that I do. We help people that have errors on their credit reports. We don't charge them for that. So the question is, well, why would you guys do that? How do you make money? Well, we're very upfront about it. If stuff gets fixed, we don't make any money. if it doesn't get fixed and we have a good lawsuit, we sue the bad guys, and that's how we get paid, is out of that settlement. So, on anything that is free, always ask, and that's what you're doing. Like, how's the person making money? So I don't specifically know about that website or that company, but I would just, if they don't tell you directly, I would just ask them, like, how are you guys making money on this?
I've never heard of Versio either, but I can speculate there's a couple of things going on. Number one is, the reason that a lot of credit repair entities, I'll call, for lack of a better word, a lot of folks who are involved in the credit repair, they understand that there's limits on what federal law allows them to charge for, and so they know that they can't do that up front. But what these folks might be doing is they might be trying to feed well-prepared FCRA cases to lawyers. They may be, and I say this because I'm not familiar with them. They might be saying, well, we'll feed those to lawyers, and they're going to ask lawyers to pay them for leads. That's a possibility. So I want to make sure that in a case like that, before you trust anybody with your credit information, you want to make sure that you're dealing with somebody, A, reputable, and B, you want to make sure that you're dealing with somebody who's going to keep your information private, because your credit information is very private and can expose you to a lot of vulnerabilities. In every state that I'm aware of, a lawyer has a legal duty to keep your secret secret. So if you were to share a credit report with a lawyer, they're required by almost every code of ethics I'm aware of to keep that private. And so they're not allowed to leak it. But another company that's not subject to those requirements might have a different business model, and they might have a different viewpoint about how much privacy is required. So I just be careful about some of those things. Again, no comment specifically on that business, because I'm not familiar with the business either. But those are some of the things that might be going on.
Yeah, so that's good. So Brandy, hey Brandy, good to see you, and definitely let us know if you have any questions here. And let's see.
I'm seeing a lot of good questions in the chat. So I'm hoping we can tear through all these. These are really good. This is good stuff.
Yeah, I just have to be careful because it kind of like scrolls up and I lose my place, and I cannot multitask. So but we'll try to knock these out one at a time. So here's one. I've disputed inaccuracies on TransUnion and Experian on a repo charge-off 2016. It's reporting terms inaccurate. Dispute with both bureaus. They refuse to update or even delete. So, the general rule is you find inaccuracies where it's just flat out wrong or there's incomplete information, you dispute it. There's only three possibilities, three legitimate, I should say. One is they fix it. Second is they delete it. Or three, they say, please sue me because we want to pay you money. Okay. Yeah, there's a few others. They can say, well, we think this is frivolous, or we don't think you really did the dispute. But if your disputes are legitimate disputes, actual errors you're identifying, and I harp on this all the time, use your real credit reports. It's fine to start with like a credit monitoring, but make sure you get your real reports and verify everything. And you can get those through annualcreditreport.com once a week for free. And if you have done good disputes identifying the errors and they're not fixing it, then get with Mike, get with me, get with a lawyer who does this type of work, and see what your options are. What are your thoughts, Mike?
Yeah, I have some thoughts that jump out at me right away. Number one is I want to underscore what you said about legitimate disputes, about legitimate inaccuracies, something that is actually incorrect, something that is actually too old. Those are good disputes. But something jumped out at me about showing TransUnion and Experian, and I believe that suggests to me that this particular person is disputing, I'm guessing, through Credit Karma. Mm-hmm. And that's the real credit report issue that you talked about. Credit Karma, while a useful starting point to alert you to problems that might be in your credit report, you're getting a filtered version of the credit report through them. And because I look at it, right? I look at it from my personal information too, and I've noticed that it used to be much more transparent. Now it's much more filtered than it has been even the last 2 years. And so the information you're getting is not directly from from the horse's mouth. You're getting it from a third party who's filtering it. And if you're taking advantage of their, click here to dispute button, then you're also going to find, in my experience, that dispute is going to be less likely to be taken seriously, because you're giving them less information than you might otherwise in a letter, and because it's a low bar to entry, they figure you're a low effort person, or you're making the least effort possible to dispute this. You're not likely going to be a threat to them. If somebody sits down and writes out a letter by hand and says, here's the problem with everything I've got, and here's the actual inaccuracy, and I've looked at my actual credit report and here's why it's wrong, and mails that in, certified mail return receipt, you can bet bottom dollar that person is sending a red flare to the credit reporting agency saying, fix this or I'm gonna sue you. And you don't want to say that in your letter. You want to say fix it, but by sending it certified receipt, by taking the time to write a letter out, you are showing them that you're serious about your credit. You're showing them you're serious about fixing the mistakes. And if they don't, they know you're likely going to be serious about actually taking them to court.
Mike, I think I've mentioned this before. In my office, we have sort of a joke, but it's true. We say no good news comes by certified mail.
That's true. That's true.
Certified mail is, if I send Mike certified mail, it's I want him to get it, and I don't want him to be able to lie about not getting it.
Well, yeah, you're not telling me that I've won the lottery.
Right.
So.
Yeah, the IRS sends certified mail, not because they want to support the postal service. They do it because they want to be able to show, see, you got it.
Yeah, you got it. That's right. So, time is ticking.
That's
not only that you got it, but when you got it.
Right.
Which is important for FCRA disputes.
So let me go back to this, because Albert said this is a charge off. And so, let's go back and sort of reread this. As my experience keeps reporting on a charge off as derogatory delinquent late payments, tried to correct them, no luck. So one thing, Albert, would be, if it's accurately showing as a charge off, unfortunately, that can show every month, January, February, March, April, May, just all the way through a charge off. But if you are disputing, again, like we're talking about, and like, Mike talks about in his videos, I talk about in my videos, you've got to find actual errors. So it's not enough. I'm not saying you're doing this, but I'm just using this as an example. You can't just say, hey, please verify all information about this account. You've got to specifically identify in May 2019, here is an error on the payment history. Or, Equifax says my high balance was 10,000. Experience says it was 12,000. Well, which one was it? There's some discrepancies here or incomplete information. And then what Mike was saying, make sure you're using, your actual credit report. So I dropped the link in, should pop up as a comment, annualcreditreport.com once a week for free. These are your real reports. And then I would do them by certified mail, because again, it just shows there's a more serious nature to it. It's kind of like somebody sends you a text versus somebody sends you a handwritten 2-page letter. We kind of go, wow, that person spent more time. Now, you don't have to handwrite your letter, but, type it, handwrite it, I don't care. But I would do it by certified mail. And then if you're still running into problems and there are errors and you've told the bureaus about the errors, then definitely get with a lawyer about that. So let me see here. So we've got Jeff on here. Well, Jeff, we are very happy to be here, and thank you for being here as well. And let's see, Woolly's Coder too.
Yeah.
So we're presuming that this is a very smart computer person here. And thanks for doing this, guys. Well, again, you're very welcome. And let's see here. Okay, so here's a little bit more information. The repo is a charge-off reporting late payments, date of last activity, date open, as well as terms are inaccurate across the board. What would you recommend? So again, just make sure that you're not basing this off of like a smart credit, identity IQ. Make sure you're looking at your real Equifax, Experian, TransUnion reports, okay? if you see these discrepancies, I mean, there can only be one date of last payment. I mean, it's sort of like saying, and Mike, lives in the Tampa Bay area, and I don't know if he's a Buccaneers fan or not, but there was only one Super Bowl winner this last
That's right.
Super Bowl. We can't say, well, there were multiple Super Bowl winners in 2021. No, there's only one, and that guy happens to have a whole bunch of hardware on his ring, on his fingers. And, so if the late payments, like the date of last payment, the date opened are not consistent, then I would definitely dispute. I would make sure about this. You might have one report says date open 02/2017, February 2017. Another one might say 02-03/17. I mean, you could dispute that. I wouldn't necessarily be excited about suing over that. Okay. So what makes it more interesting is one bureau says you opened it in March. The other one says you opened it in April. Another one says February. Now that's the difference. Okay. So again, just make sure you're using your real credit reports and then point out every discrepancy, every inaccuracy, every contradiction, and you'll go a long ways towards that.
Yeah, one thing I like to do is I like to look at all three original credit reports, because if you can find that they're reporting three different, again, there can only be one correct answer for a lot of this stuff. So if you're not getting the same answer across the board on all three, at least one of them must be wrong, and maybe all of them are wrong. And so you can say, hey, listen, you're reporting this date, but Experian is reporting this date, and TransUnion is reporting this date. One or all of them must be wrong. Please investigate and fix, right? And maybe they investigate and find out that they're all wrong, or maybe they fix it. And you want to identify things that actually are causing you some harm. So, for example, with dates of first delinquency, the older that date is, the sooner it comes off of your credit report. So if they have a more recent date, an incorrectly more recent date, then that's going to be on your report longer than it should be. And so that's an inaccuracy that can cause you harm, and that's something that they really need to fix. So if you can identify those types of things, that's going to be what you want to dispute.
Let's see here. So we have, is it better? This is a great question. I don't think anybody's ever asked me this before.
I have a whole video on I have more than one video on this kind of thing, actually, but generally speaking, any time you spend on the phone is wasted time, in my opinion, with credit reporting agencies, with debt collectors, because nothing you say can help you, and nothing they say can help you. And the people who are answering phones in the phone center are usually not empowered to do anything for you. They don't have any authority. That's why they're working in a call center, right? They're not people who've been trusted with a great deal of discretion, and so by their employers. And so their job is to get you off the phone as fast as possible while giving you as little as possible. If you want to do something, if you want to dispute something, and you want to prove you disputed it, you're going to send a letter, and you're going to do it certified mail return receipt, just like we were talking about earlier. So, John, I'm sure you have some thoughts on this too.
Yeah, and so the question is, in case somebody is just maybe listening to this, is it better to send dispute letters to the credit bureaus or dispute the items over the phone?
Right.
And then person points out, all I have disputed over the phone come back as verified in a matter of days. So
I'm shocked.
Yeah. And so I'll give you my take on it. I do think there are times where over the phone can be helpful. The biggest problem, though, is proving what was said.
Yeah.
Okay. Never assume the bad guys who are not following the Fair Credit Reporting Act, okay, or the FDCPA or whatever it may be. Never assume that they are going to keep the recordings of the calls if the recordings hurt them. I can't tell you how many cases, my client will say, John, here's what happened in the phone call. And we can prove there was a phone call like that exact date and time. We've got our cell phone records. We called this number as a 17-minute, 14-second phone call. And the company will say, John, you'll never believe it. We had a computer glitch and that recording got deleted. Like, really? What a shock. It's happened the last 8 times we've sued you. So understand, if it hurts you, they will have the recording. There's never a computer glitch if it hurts you. If it hurts them, there will always be a computer glitch. Now, of course, if the bureaus or debt collectors are watching this, they're, like pounding their fist in there. That's a lie. We never do that. We do everything above board. Well,
Sure.
Mike and I have some oceanfront property to sell you in Arizona, if you believe that. So here's the thing. If you're going to do it by phone, make sure that you can record the call. Okay. I always tell people, assume you're in what's called a two-party state. Okay. So Florida is a two-party state, right, Mike?
That's exactly right.
Yeah. Both parties have to agree to the recording. Alabama's one party, but it's a complicated question that you never want to have to answer. What if you're standing in Alabama and you call Florida? What if somebody in Florida calls you? What if you call my cell phone and I've just crossed over into Florida? Is it two-party or one-party? So what I would do is, if you call these places and they say, as soon as you get on the phone, they go, please be advised, all calls may be recorded or monitored for quality control purposes. Well, in my view, they've just said all calls may be recorded. Okay, they gave me permission. There's one. I give permission. There's two. 1 + 1 is 2. I feel good about that. And thing I would tell you is just test it first. Okay. If you can get an app on your phone, test it. The easiest way is do it on speakerphone, record it on your iPad, your laptop, your husband, your wife's cell phone, voice memo recorder. Just test it. I get recordings all the time. People are like, these are fabulous recordings. And all you can hear is one side, or it's complete silence for 38 minutes. But here's the other thing with the phone calls to the bureaus is it's hard to give them any information. Like so give you an example. Mike and I both defend people who are sued by, let's say, Midland Credit Management. Let's say we win that case, and then we want that off of our report. We'd want to send in the complaint and send in the order where we won. Kind of hard to do that by phone. You say, well, I have that. And they may say, well, I don't see it. So I would not be real inclined to do it by phone, unless maybe this is like after the third or fourth and you've already sent in all the information. But just make sure that you can document that call. That would be my suggestion for you.
Yeah.
Let's see. Here is something from Jeff. And Mike and his partner are like, Mr. Foreclosure defense guys in Florida. So this will be very much on his mind. So what's the most common foreclosure error committed by lenders? And then second, will they continue these errors going forward? And Jeff, I'll just add something to that. I think Mike and I both believe foreclosures are coming back with a vengeance. And so, Mike, what would you say is the most common foreclosure error that you see in Florida?
Well, it's hard to attribute just one particular thing. I'd say in foreclosures, because one of the things to remember is that Florida is what we call a judicial foreclosure state, meaning you can't foreclose unless you go to court and convince a judge that you have the right to foreclose. That's not terribly difficult to do, but you have to file a lawsuit and do all the routine things. And so what I see a lot of times are, where banks don't keep the proper records of what they're supposed to keep track of. And in fact, where you have a foreclosure case and there is what's called a servicing transfer in the middle of the case, meaning that the mortgage servicer that handles the billing and handles the account management, that company changes no matter who owns the loan. But like let's say you're dealing one day with Mr. Cooper, which is now known, which was the new name for Nation Star. And then one day it changes to, let's call it Bayview Servicing, right? In that handoff, oftentimes you'll find mistakes. And so you might find things like losing the note. You might find things like dropping the ball on a pending loan mod application. So if you have a loan mod application and you want to modify your loan to get you back current, and they hand it off to a new company in the middle of that process, that's where we see things drop the ball. So those are some of the things I see. And I think that the difficulty of managing, in particular, loan mods in the wake of the pandemic and all the rule changes that have gone on under the CARES Act and under servicer guidelines, I think that is going to become more difficult for servicers to get it right than they found in the past. So I think that the loan mod application process, especially with the servicer transfer, is going to be where a lot of balls get dropped. And I think that's where a lot of litigation will be happening in the future.
Yeah, I agree. I mean, ultimately, it comes down to the servicing companies are trying to do this as cheaply as possible.
Yeah.
And so, I mean, we see, they might have a yearly turnover of 60 or 70% of the people that would be the folks that you would deal with on the phone, by letter, by email. And so they're trying to pay people as little as possible. And there's just mistakes that happen. And at some point it becomes the mortgage company sort of purposely closing their eyes to the mistakes. They know it's happening, but they figure you're not going to do anything about it. So, with foreclosures and mortgage companies, all this stuff sort of comes together. Stay on top of your credit reports. I mean, we'll see companies reporting that, like, let me give you an example. And Mike referenced it, this CARES Act because of the pandemic. So basically what that says is if you get an accommodation, it doesn't have to be a mortgage company, but it could be a mortgage company, credit card company, anybody. You get an accommodation, they say, pay us nothing, pay us $1, pay us $5, whatever they say. As soon as you get that, we take a picture, a snapshot. And if you're current at that moment in time, in other words, you're not 30 days late, you have to stay current during that whole period of accommodation. So for federally backed mortgages, we could say back in March of last year, April last year, hey, I've been affected by COVID. I need a forbearance. And if we were current, they had to keep us current all the way through. Well, we're seeing credit reports that are showing either no data, which that's not what the law says. It says show us current, or 30 days, 60, 90, 120, 150, 180, charge off, foreclosure proceedings begun, all sorts of inaccurate information. And then what Mike was talking about, kind of that handoff where one servicer hands it to another, it's very common for them to accidentally, they say, forget to tell about, oh yeah, the $10,000 of payments you had. And then the new servicer says, well, we don't have to look beyond our paperwork. We don't have to go back to the original servicer. And so credit report errors, just documenting. If you're dealing with these companies, and I harped on this, in the Great Recession, just telling people over and over, if you're sending in a loan modification, now usually they'll give you like a FedEx package, but if they don't get cheap. Okay. Don't say, well, I'm just going to put a few stamps on it. No, send it certified, send it overnight. Like if you're trying to save a $500,000 house, don't save $2 on your postage or $10 on your postage. Okay. I literally have seen people lose their house because we could not prove when certain documents were received. So literally to save $10, they lost a couple $100,000 in equity. It's just insane. So use certified mail, use credit reports, and just really push these guys if you think there's any errors. Let's see here. So Shadow Smurf says, thank you both providing information. Good or great interactive way. Well, you're very welcome. We enjoy doing it this way because, I'll say we would get bored talking to each other. It's not true because when we talk for like ever. Our batteries die on our phones and stuff. But it's much more interesting to, get questions from you guys. So let's see. Brandy says, and this is so long, Mike, I've lost you there. I think somewhere. So, let's see. When it comes to utility accounts, read several things on how it should be reported. Don't know if it's true or hearsay. Is it compliant for a utility company to report an account as charge off, or should it only report as a collection? Also, is the company supposed to be reporting full payment history, not only charge off months? Company hasn't sold the account to collection. So it's a great question, Brandy. I'll say this. In Alabama, I rarely, if ever, see utilities on credit reports.
Yeah.
Now, it may be more common in other parts of the country, or maybe I'm just not, seeing the right credit reports. But in general, I'll say this: if they're reporting, they're supposed to report complete history. So let me give you an example. If I have a credit card from the Bank of Mike, and I pay Mike, yeah, it's really high. It's a terrible term. Customer service is beyond horrible. Okay, but he gave it to me, so I'll take it. So let's say 11 months out of the year, I pay more than the minimum payment. I mean, I pay it off, but every December I miss a payment, and so Mike decides he's going to credit report, and he won't report January, February, March, April. He only reports every December when I'm late. That's not accurate credit reporting. Well, I'll say this. What he's reporting is accurate. I am late in December.
It's not complete, though.
It's incomplete. Yeah. And so I would dispute that. And whether it should be collection or charge off, really collection is when it's a third party collector. Okay. So if you have literally like your utility company reporting on you, I think they should report as a charge off if it's actually gone to a charge off. Mike, do you see, TECO or other companies there in Florida reporting utility?
No, not really. I do know, however, that a lot of the credit reporting agencies are now offering services that purport to bolster your credit report by gathering more information. So, like I want to say it's Experian that does this. They have a product where they say, well, give us permission to look at your utility bills. And if you're paying them on time, we're going to add that information and it could make your credit score go up. I'm like, well, that's great. Just make sure you paid it on time every time before you give them permission to do that. So right. I'm not aware of any special rules for utilities, but I just do not see a lot of utility accounts on credit reports.
Yeah. And so, Brandy, if you are still with us, and maybe tell us which company that you're seeing, and what part of the country that's in, because I'm curious about that. Let's see. We have CR says, Discover Bank keeps reporting my account as past due on credit reports while having a collection agency also collect on their behalf. The attorney filed suit. I've not been served. So a few things to unpack there.
And by the way, there's a couple more comments throughout the thread that I've seen CR put out there. So there's a summary judgment pending and a whole bunch of other facts that are related to this one.
Yeah, so we've got summary judgment and let's see. Creditor files suits, you've been served. Can court keep it open indefinitely? Okay, so we'll try to keep all these, and then Mike, remind me to go back in the stream of comments here. So I'll tell you how it is in Alabama, and then Mike will tell you for Florida. It's up to the judge how long a case can be open before you're served. I have had people where the case has been left open for 5 years and then they get served. Pretty unusual. Okay. Normally it's more like maybe 9 months, but that is going to be very state dependent. It may vary depending on what state you're in. And even within a state, which judge you have. So like our Alabama rules of civil procedure would say, I forget the 120 days, I think is the normal time, but it's always within the judge's discretion to give the creditor more time than that. Mike, what are you typically seeing in your debt buyer lawsuits? Will the judges leave it open for a long time?
So I was just looking up the rule because I believe it's Rule 1.070 that applies to Florida cases that talks about service of process, and it's I want to say it's 180 days, 120 days rather. And if you aren't served in the 120 days, you either have to ask the judge for more time, or the case should be dismissed, against that particular person without prejudice. If they can find you later, they can come back on you. But there is a time limit there, and the judge has some flexibility if there's good cause. If somebody comes back and says, well, we know they live here, and we know there's a car in the driveway, and the shades are drawn, and nobody answers the door, and we keep trying, the judge is going to give them a little bit more time to try and tag you. So, in Florida, the case is going to be closed after a particular time limit, but that can vary. I've never heard of anything going on more than a year, though. That's not that I've seen at all.
Yeah, and so going back to just this idea of, so Discover Bank can certainly credit report on you, and they can have a collection agency, collect on you. What they can't do is, so let me give some numbers. Let's say you owe $5,000 to Discover. They can't be on your credit report saying you currently owe $5,000 to them, and a collector's on there saying you owe $5,000, because that looks like you owe $10,000. That would be inaccurate. So Discover would have to show a zero balance. Hey, we've transferred this to somebody else. But sometimes the collector doesn't report, and they can also sue. And so you say you haven't been served. And so, Mike, let's just make sure everybody's on the same page. What does it mean to be served in a collection lawsuit?
Well, most states have some variation of this, but in Florida, to be served with a lawsuit means a process server will come to your house or find you at work or wherever and will deliver a summons and complaints to you. And in Florida, if they come to your house, they can also leave it with anybody over the age of 15 that lives where you live. So if you have, older kids, or you have a spouse, even a parent or a roommate that's over the age of 15, the process server can leave it with them, and you've been served in that way. But there are some states where service by mail is possible. I've seen, I think it's Texas, where they're now authorizing service by social media, which is, to me, is insane.
Yeah, that is crazy.
but there's Florida pretty much, it's going to be somebody physically handing you a piece of paper. And, one of the myths that people have is, I didn't sign for anything, or, you don't have to accept service. The process server will just find you, and, they can drop it at your feet and say, that's, you've been served, and it's your job to respond to it at that point. But you're not, your participation is not required, only your presence.
Yeah. So you may remember this, Mike, in law school. I'm sure you would have covered it. There's a part of law school where we're talking about how do you start the lawsuit by serving somebody. And there's an example of serving somebody on a plane. And so the process server gets on the plane with you and waits until like the pilot says, okay, we are now over Nevada. And then like, hey, Mike, you've now been served. You don't have to agree to it. You don't have to say, well, I approve this. It's no, you've been served,
And we're in Nevada, right? So
right.
Have to go to Nevada court, right?
Yeah. And so, for example, in Alabama, we have service by certified mail. And I know a lot of states don't do that. We do that. I think some states may even do it by regular mail, which is absolutely crazy to me.
Well, I heard of that for the first time the other day when I talked to a lawyer from Mississippi who said that her client had gotten service, had received the mail the day before trial, and that was somehow legal in Mississippi. And I have some strongly held opinions about whether that's proper or not, but I don't think I'm licensed to go into those right now. So I won't.
And then let's see, one last thing here. The attorney's requesting summary judgment. Can I request dismiss with prejudice or arbitration? So my first thought would be there shouldn't be summary judgment unless you've been served. And now one thing that happens is sometimes the court thinks you're served and you think you're not served. And this is where I definitely take a minority position on this issue. I tell people, and we certainly do it, we answer lawsuits even when we've never been served. I do not wait to be served because you're taking a chance. That process server may serve your neighbor, legitimately think it's you, and tell the court, I served you. And now the clock is ticking, but you don't know about it. So, or they throw it in the shrubs in front of your house and tell the judge that you were served. And now you're trying to disprove that. So I like to answer even before we've been served. At least in Alabama, you would not have summary judgment without being served. So that would be my first thing, is check and make sure you believe you haven't been served, but see what the judge believes.
I think I saw a comment elsewhere in the thread from CR saying that he confirmed online that the process server returned it unserved. So I think in this limited fact pattern, somebody's confirmed it, so that's probably okay. Some states allow the filing of a motion for summary judgment before the defendant answers, before the defendant's been served. Merely filing it, though, doesn't mean they can have a hearing. It doesn't mean that the court can consider it without someone being served, because in every state I'm aware of, Florida certainly for sure, unless you've been served, the court doesn't have what's called jurisdiction over you, meaning it doesn't have the power to hold you responsible for everything until you are given notice of the proceedings in the legally approved way. So there's that. Can you request dismissal with prejudice? Well, you can do that at any time that you participate in the process. If you do that, remember, you might be waiving service. In other words, you might be giving up the right to challenge service. I think that's a question I'd want to have an attorney weigh with you about whether you should do that and what grounds you might have. But arbitration, if I recall correctly, this is a Discover card, and many Discover cards, many Amex cards do have that arbitration provision in there where you can invoke arbitration almost at any minute. Like you'd be walking in on the day of your jury trial and say, "Judge, now I want arbitration," and the whole thing grinds to a halt with the needle scratch on the record. Now, your arbitration clauses may vary from contract to contract, so be sure you know what you're asking for before you ask for it. But that can be an effective tool, especially if you're talking about a smaller debt, because the cost of arbitration may outweigh anything they'll ever recover from you. And they might not want to do that. I've seen that with Discover in particular.
Yeah, and sometimes they'll do it even when it makes no economic sense, just to send a message to say, "Hey guys, this is not a get out of jail free card. We'll spend $5,000 to recover $2,000."
Right.
Just so people don't use the arbitration approach. Let me go back to see if I can pick up where we were. Oh, let me do this. I'm sharing a comment that it should be, Mike, your YouTube channel. If you heard something, if you said, it almost sounds like as I'm talking that I hear myself talking, it's because I opened up your YouTube channel and a video started playing. And so I think that's the correct link there for you. And so definitely everybody, subscribe to Mike's channel. He puts out really good videos, and highly recommend those. Let's see here. So here we have major credit card agency is making calls on my cell phones on Saturdays and Saturday evenings and during Monday through Friday multiple times a day. Shall write a letter to the credit card agency, cease and desist. So here's where we have to make a distinction. Is this the credit card company or is this a collection agency? It sounds like it's a collection agency. If it is, you can certainly write them a letter that says, "Hey, cease and desist," or "cease communications," or "I refuse to pay." Those are all the same thing. This is under Section 1692C of the FDCPA. And you have the right to do that. Now, they have to stop calling you. They could sue you if they have the right to sue you. They can credit report on you, but they have to stop calling you. So that's one approach. Another approach is you could say, "Hey, give me some information. I dispute this debt or any debt that you have on me, but give me some information," and see what they do. And then if they don't give you that information, and here's a little hint, they'll never give you the information. Then you can say, "Because you won't give this to me, I now refuse to pay this debt." And then sometimes they go, "Oh my goodness, we kind of got too cute here." And then they send you the information. Guess what? They just violated that section of the FDCPA. So they know about all this and they choose to violate because 99.9% of people will never do anything about it. So it's very low risk to them. And do you have any other thoughts, Mike?
I do have one thing to add. Is that we mentioned earlier Florida's Collection Practices Act.
Oh, that's right.
Consumer Collection Practices Act. And what's interesting about Florida's statute is that it also applies to original creditors collecting debts. So if this was, let's say this was a credit card company, call it Amex, right? Whatever. And they're making phone calls to you all the time. And you tell them, please stop, or even better, you tell them, I have a lawyer. Once you tell a creditor that you have a lawyer in Florida, they are required to communicate only with your lawyer. So if you say, I've got, Mike's representing me on this particular account, and they send you a letter demanding payment, or they make your phone ring demanding payment, they have broken the law, and that's $1,000 in your pocket under the Florida statute. And if it's the original creditor, they violated the Florida law. If it's a debt collector acting on behalf of the original creditor, then it would be possibly a violation of the federal statute as well. So then you have that stacking that we talked about earlier. So that could be a $2,000 phone call just for having having a lawyer get involved, even very briefly.
Yeah, it's a good point. So let's see. Cedric says open date on charged off medical debt on the credit report. Is it when the medical procedure was performed or when the debt was charged off? Some call it the transaction date. So my view on that, Cedric, is if we're talking about a collector or a debt buyer, the open date on that's going to be when they receive the debt. But if let's say it's a hospital, it's a doctor that's literally credit reporting their own debt, well, then the open date would have to be when the procedure was performed. And so that would be my view of it.
Or when the charge was made to the account, because you might have a procedure done on a Monday and they don't run the bill till Friday. That would be when but I think probably more important, the open date matters, but I think what you probably want to look at is when is the bill actually delinquent, because that's what starts the time ticking for removal from the report, because that's the 7-year period. So it's not so much. The open date is relevant because it tells you, it's likely to tell you when the procedure was done or when the doctor's office billed you, so that helps you narrow down what was actually charged, but and whether you actually received the procedure, for example. I've heard of some medical providers billing for things that were never actually provided. Horrific stories, like there's one that I'm aware of where a local hospital was billing for nursery care for newborns, even to mothers whose children had died in birth. And you can imagine the kind of emotional turmoil there. So when they found out, wait a minute, you billed me for nursery care, my child went, unfortunately, straight to the morgue. You can only imagine the kind of anguish that caused. But in terms of what should be on your credit report, you probably are going to want to look at when the bill was deemed to be delinquent, when the payment was first late.
Yeah, and I just because I know Cedric, and I know sort of how he does things. He's looking for all the errors that are on there. And so some errors are more important than others. But, the thing is, if they're reporting negative information about us, then whatever they're reporting needs to be accurate, because FCRA says we can dispute any item that's inaccurate or incomplete. And, Cedric definitely holds their feet to the fire on that. So he does a really good job with that. Let's see. So here's our coder. Is there anything special when a collection agency listed a dispute account as completed investigation of FCRA dispute, consumer disagrees? So
we were just talking about this on Monday.
Yeah, we were. So Mike and his law partner, Jason, and I were together on Monday for, I think we were going to meet for like 2 hours, and it was like 6 hours later. I'm like, I better leave before they kick me out, So, but yeah, we were talking about this. So keep in mind, there's 2 laws, right? There's the FDCPA. And if you tell a debt collector, or even if somebody else tells a debt collector, you dispute the debt, they have to mark it as disputed. This is section 1692E8. And so that's one thing. Now, the FCRA is another. And so if you do a dispute through the credit bureaus, then what the credit bureaus are now telling all these furnishers, and this is through Metro 2, kind of their rule book, or here's how we want the data, is while it's being investigated, it can say consumer disputes. But when you're done, they want some finality to it. And this is one example: complete investigation, consumer disagrees. This can be, is not always, but it's possible this complies with the FCRA. To my view, this does not comply with the FDCPA, because the FDCPA doesn't talk about, well, now the dispute's been completed or investigated. It just says, hey, debt collector, if you know that Mike disputes his debt, you better mark it as consumer disputes. And when they say, well, you did that, but we're going to use this other code, they're running a risk doing that. And some judges will let them get away with it and some won't.
Now, John, I wonder if you've run into this. If I were to send a dispute to the credit reporting agency, TransUnion, Equifax, Experian, and they communicate that dispute to the original creditor, is that knowledge of the creditor of a dispute sufficient to trigger its obligations under 1692E8, which is the must report as disputed?
Yeah, so I think it's a great question. So, again, if we're talking about a debt collector, so not, credit card company. And I know for you with your envy producing Florida state law, which I would love to have in Alabama, that does apply to original creditors, but for the FDCPA only debt collectors, yes, that would be enough. And so what we have to prove is that, you've got the credit bureau here, that they actually sent the notification to the debt collector. And typically this is done, it's called ACDV, automated consumer dispute verification. And so if they do that and it gets updated and not marked as disputed, then yes, I would sue on that under the FDCPA. And remind me, doesn't your Florida version basically say, like, if something's disputed and you credit report, you need to mark it? Or am I remembering that wrong?
It's a little more complicated than that. I mean, Jason and I were actually reviewing it over lunch, and it's like, if they're reporting, if they're disclosing it, so it's a disclosure to any third party, and it's disputed, and they fail to notify the dispute, then that can be a violation. And if it's already been disclosed when the dispute rolls in, so let's say Amex reported something last month to your credit report, and 2 weeks later you send a dispute to Amex, they then have a duty to tell you, if you ask for it, everyone they've told about it before the dispute. So you say, hey, Amex, I'm disputing this. By the way, tell me everyone you've disclosed it to. They have to give you a list. Well, here are the 3 agencies we told about it, whatever, right? And they have to do that within 90 days. If they don't do that, again, that's potentially $1,000 in your pocket. So it's this weird kind of convoluted statutory scheme. Yeah, and I mean, we're sitting there kind of like mapping it out on the napkin at lunch, and it was kind of funny. But there are some remedies there, and that can apply even to original creditors for improper disclosure of debts and disclosure of debts without that dispute verification on there. So, and I wanted to add one more thing. It's that if a creditor if a debt collector under the federal statute or a creditor under the Florida statute is reporting something without noting it's disputed, one of the things that we believe is enough of a dispute is if they sue you, like, for example, a junk debt buyer, Midland Portfolio, LVNV sues somebody, and you file a written answer saying, I dispute it, right? That is something that we believe is enough to put them on notice that if they're reporting on your credit report, they have to say, by the way, consumer disputes. And I don't think they can truthfully say that the dispute has been resolved as long as the case is pending in court, because until the court resolves it, that dispute is still open. So
that's right. That's right.
I haven't tested that particular theory, but we do believe that a dispute in an answer that you file with the court is enough to put the creditor on notice for purpose of that statute.
Yeah, I think you're absolutely right, because it's the ultimate dispute letter. It's this, answer filed in court, all these obligations to when we file stuff in court. So I think that would be great. Let's see here. Here's a very good question from Wayne. Yeah. Do all 3 credit bureau reports have to have the date of first delinquency? If so, is that grounds for the account to be deleted? So I'm going to give you the theoretical answer and the practical answer, and then maybe another practical answer. So I believe theoretically, yes, they all have to show that. And that the date of first delinquency, as Mike mentioned, is sort of your trigger date for what keeps it on your report for 7 years. So we need to know that date. Only Equifax reports that. Experian does not, TransUnion does not. There have been some court cases wrongly decided, in my view, that say, for example, TransUnion does not have to report it to you unless when they sell your credit report to others, they put that in there. But if they don't put it in what they sell to others, then they don't have to give it to you when you get what's called a consumer disclosure. Just a fancy way of saying when you get your own credit report. I think that case, and there's a couple of, I think those are wrong.
I think that's wrong too. That's because I think they have to disclose to you all the information that they've got on you so you can correct it if it's wrong.
Yeah. And so the argument from the court, again, I think is wrong, is they say, well, so the FCRA says you are entitled to everything in your file. And file is defined as, with very few exceptions, everything they have on you. And the court said, well, we're going to redefine file to mean what they have on you that they sell to others. And since they don't give this to others, but here's the practical way we do it. In every negative account that I dispute, I say, look, you're required to give me the date of first delinquency. Equifax, you say it's this date. So let's just say January of 2016. Well, that means it should come off about January of 23. But Experian and TransUnion won't give me that date. They'll give me the estimated date that it will be removed. And they're different. So they might say November 22 and Experian might say March 24. And so we just put all that in the letter to say, hey, Experian, TransUnion, you're not reporting it. Your dates don't even match, and none of them match with Equifax. This is why I need the date of first delinquency. So give it to me. So we always want to, when we can, when we ask for something, explain why we need it. Why is it important? Well, here's why, because I can't figure out the date of first delinquency. Y'all are talking about estimate. What do you mean estimated? Like a furnisher must give the date of first delinquency to the credit bureau. And so the credit bureaus have to have it. So there shouldn't be any, well, we think it might sort of
no estimate involved, right?
The planets and the stars in alignment. No, just tell me when. You know, I got a lot of complaints against Equifax. We sue Equifax a lot of times, but at least they give us that date, you know. And one last thing I'll say about that date is check with the payment history, because I have seen more than one time date of first delinquency, January 2018. And then you go to the payment history in Equifax, January 2018, perfect. February 2018, perfect. You're like, well, how was it delinquent then? So there's these sort of inherent contradictions. And so you really have to study the report. And Mike, do you have any other thoughts on that?
I mean, my instinct is that you know, they do have to have that information, because otherwise they can't calculate when it's removed. And I think that the court constrained reading of the word file. I'll put it this way, you know, based on some recent U.S. Supreme Court activity, I think Justice Thomas might have some things to say about that. Like, no, the word file is, you know, the statute means what the statute says. And he might accidentally side on the side of consumers in that one. But so it'll be really interesting to see if that case ever got taken all the way up, because I think it might come down the way you and I think it should say, as opposed to what these courts have done. And I don't understand why they would constrain it in such a way.
Yeah, and so just give everybody sort of real quick version, and these are obviously stereotypes, but conservative judges tend to be, we're just going to read the law as it is and not worry about what it should be. Maybe I think there's some improvements. It's just, this is what it says. Liberal judges tend to be, yeah, I know that's what Congress said, but times have changed, or there's other factors involved. And
what are we really trying to do? Yeah.
Yeah. And it's, you know, it's kind of like, I was listening to some people talk about cancel culture. And they said, conservatives hate cancel culture unless it's a liberal doing something stupid. And then it's like, you should be canceled, like kick you off the Olympic team or something. And, liberals are like, we should be free speech unless it's something I don't like. So basically both groups want everybody canceled that doesn't agree with them. And so same thing when we're talking about judges, it kind of depends on, are you on the winning side or the losing side, whether you think these guys are good. But there definitely is a movement towards just applying the law as it's written. And Mike, I think we talked about this. There's a recent case from the 11th Circuit, which is our appellate court. So Georgia, Alabama, Florida for federal matters. And they looked at the FDCPA, a section nobody had ever really argued before. And they said, well, if a debt collector sends your information out to a mailing house, a vendor, that's a violation of the FDCPA.
That's a disclosure. Yeah.
And the 11th Circuit opinion that was written by a Trump appointee, who we presume is very conservative. I don't know the person personally, but he said, look, maybe nobody's brought this up before. It doesn't matter. This is what the statute says. You violated the law. I know your entire industry is based on this. Maybe you should change your industry, or maybe you should get Congress to change it. Now,
and the law is very, very clear. It's written in very clear terms. It says, can disclose to the debtor, the debtor's attorney, the creditor. I mean, there's a list, and they're very, very clear about who's in there. And mailing vendor is nowhere in the statute.
And so all these companies are having this complete meltdown about, but this is what we've been doing for 40 years, and this doesn't make any sense. And why would you do this? And so again, what Mike was saying about there's definitely a conservative movement, whether you like Trump or hate Trump, he did a fantastic job of putting a lot of judges on the court. And so we may be in a better position for this thing about file, when it says all your information under the FCRA, well, then give it to me instead of not giving it to me.
Do you remember which judge that was that wrote the opinion? I'm trying to look it up right now.
I don't remember, but it's the Hunstein decision. Yeah. And it's, and just so everybody knows, this is on what's called a rehearing en banc. En banc just means all the judges of the 11th Circuit. I think we have like 13 judges. And so they're asking the entire court to reconsider this because it's such a sort of monumental decision. So it may go away, but it's interesting to, if you don't put it to you this way, if you're interested in the law, it's worth reading some of these Supreme Court decisions, and you'll learn a lot about how this stuff works. Let's see here. So we got Tony. What if a consumer did not apply, sign, or use a credit card, but original credit reports he has a joint account, does not remove it, and it's still reported as a joint account? So what I would say, Tony, is we have to take a step back and say, use me, for example. Let's say Mike has a credit card and they're reporting that it's a joint account with me. Well, the question would be, did I take out that account? Now, the way this is worded, I did not apply, sign, or use a credit card. Then it would sound like I did not take out that account. But that's something that a judge would literally just ask you, like, hey, John, is this your account? And what I have seen before is I've had people call my office and we talk, and they say, this is not my debt. And I say, well, did you apply for the card? No, I did not apply for the card. Well, is this your debt? No. Yeah, well, did you? Yeah, and they start getting really technical, and then you realize, oh, well, like their husband stole their identity, and then they found out about it, and they used the card a bunch, and so we have to be careful. We're not, and I'm not saying you're doing this, Tony. I'm just saying the judge is going to say, I need a very simple answer here. Did you have this account? And if you say no, and it's in your name, then the only option is it's identity theft. Okay. Because we're not talking about an authorized user. That's a joint account's different than an authorized user. So that would be the thing. If it's identity theft, then it needs to come off of our credit report. If it's an authorized user, you can get yourself removed as an authorized user. It should come off the report if you challenge it. Let's see here. Laura says, you're sending the same letter to all three credit bureaus. Do you also use that dispute letter to dispute personal information that's incorrect? So, Laura, I do that. I'm big on disputing personal information. So we've got old names, misspelled names. Probably once a week, I have a client that I represent in a debt defense case. When we look at their credit reports, it lists my work address as their home address. That is not correct. Okay. It's just the debt buyer has then reported my information. So we'll look on their phone numbers and it's got my work number on there. And so I'm real big on disputing anything that's inaccurate, including personal information. I do that all in one letter. Mike, how do you do that? Do you typically divide them up or do you put them in one?
I mean, I don't really have a strong preference for one letter over another, but one thing I always like to keep in mind is that if the letter is successful in correcting incorrect information, that's great. If the letter is not successful, then I have to remember it's going to end up probably in front of a judge or a jury at some point. And so I always like to make sure that I don't look like a jerk, right? And so if I'm nitpicking about a particular name or like let's say my name Michael is spelled Micheal, right? And that's, so that misspelling is incorrect, right? I'm not going to want to put that in the main letter. If I got some other really important stuff going on that I really care about and I might want to show that to a jury, I might not include that, or I might just say, oh, and by the way, here's the other thing you have wrong. It just really depends on what I think is going on in the overall context of the case. And that's kind of a judgment call. There's nothing wrong, in my opinion, with doing it in all in one letter. And in fact, it does lend some credence, I think, to the idea of like, yeah, well, here's this one big thing that's wrong. And also you've got these other 10 mistakes in here. And it just goes, it kind of goes to show like there's a whole bunch of things going wrong with the way the credit bureau is reporting your file if you're listing it all in one letter. So it just really is a judgment call. I don't have a strong preference one way or the other, but on the short side of it, is that if you put it all in one letter, you save on the certified mail postage because you're only sending one letter instead of multiple letters. So because you're going to send certified mail, right?
That's right. Always certified.
Get the green card.
So here's Doris says, not paid on an account since 2014. Now they want to sue me. So
what state is Doris in? That's what I want to know.
Yeah. You definitely want to get with a lawyer that does this type of work in your state. So if you're in Alabama, get with me. If you're in Florida, get with Mike. And it's very state specific. And so you want to know, because we could look at it. And so, for example, if you're in Alabama, I would look at that and say, if you haven't paid since 2014, if this is like a credit card account, you're not going to get sued. If you get sued, we're going to hammer somebody and they're going to pay a lot of money because that's after statute of limitations.
Right.
Okay. And
in Florida, that would be overdue in Florida too. Now, what I want to know, John, and maybe you probably want to know this too. Doris is telling us they want to sue me. I want to know how they've communicated that to Doris, because if they sent a letter saying, hey, Doris, here's your 2014 overdue account, and we're going to sue you for it, that would be in Florida, that would be a debt collection violation because they're threatening to take some action they're not legally allowed to take. And it's probably the same in Alabama if it's beyond the statute. So there are very few states that have more than 6 years on credit card accounts. That's I know that they exist out there. I can't remember off the top of my head where they are, but Florida, Florida for that account will be a 4 or 5 year statute depending what type of claim you bring. Got a whole video on that on my channel. Alabama, what's the time limit in Alabama?
Yeah, so it's either 3 or 6. Depending on kind of the theory. And let's talk about this for just a second. So they sue in Florida for account stated, right? Right. So that's a particular legal theory. Same thing in Alabama. In Alabama, account stated is 6 years. In Florida, it's 4 years. 4 years. That's why it's so important like you can listen to Mike, and I want you to listen to Mike. You can listen to me. Hopefully you want to listen to me. But understand this, your state can be totally different, even though it's Midland funding, it's account stated, everything's the same, except the rules can be different. So, use us as a resource to raise some questions, some ideas, but then get with somebody in your state to really get those details.
Now, and one more wrinkle on this too is that depending on if they're suing you on a contract, and that contract says, oh, we're going to apply the law of, say, Utah to this contract, your state might say, well, all right, well, what's the statute of limitations in Utah, even though you're in South Dakota, right? And so that might be like, I'm in Florida, John's in Alabama. We might be suing on a contract that provides I actually had a case where New Jersey law applied. So I had to look up the New Jersey statute of limitations, and it didn't unfortunately go my way. But you might be applying some other state law. So, but your lawyer's got to know that, and you've got to know the laws in your state. And if you're going to represent yourself, you've got to understand, are you applying your state statute of limitations? And if so, which one? And if you're not, what state are you going to, and how do you determine which time period applies? So these are things that can even trip up lawyers who aren't familiar with that. So it's kind of a funny area.
Yeah, absolutely. See, Laura says, can you use Identity IQ report to dispute with the credit bureau? So I'll give you my thoughts on that, and then Mike will give you his. You can just understand you're not getting the accurate information, okay? You're getting what Identity IQ says, Equifax says, what Experian, what TransUnion. So you can use it to start, but I would then get the results back from the bureaus, because that'll be their direct information. And then I would use annualcreditreport.com. And if it was me, I actually would just skip Identity IQ to start with, get to your real reports. You get so much more data. I mean, unbelievable amount of extra data. And think about it this way. So Identity IQ, it's going to have standard stuff like open date, current balance, is this joint, individual, whatever. The real difference comes in on the payment history, because all it's going to show, unless they've changed it since I last looked at it, is just were you current, were you 30, 60, 90, whatever. Your real reports will show that. Plus, for usually 24 months, it'll show what's the balance that month, what's the schedule payment, what's the actual payment, that's a whole bunch of more data that they have to get right. If they get wrong or it's incomplete, you can dispute that. So you really, it's like using Identity IQ would be like, we're in the middle of the NBA playoffs right now, saying, well, I'm only going to use my left hand. I'm not going to use my right hand while playing basketball. I mean, you can do that. And, Larry Bird did that one game because he's crazy and ridiculously good. He's like, I'm just going to shoot with my left hand. But, why limit yourself when you can have all the weapons at your disposal? That would be my thought.
Yeah, and I would say the same. I don't think disputing it through Identity IQ gets you anywhere, because you don't know what the original reports are saying. So I would go to the source and I would dispute it directly with them. John, I'm scanning ahead a little bit, and I see there's somebody from Pasco County that wants to talk. There's somebody who CR has a deficiency request on a Mercedes-Benz case. I mean, there's all kinds of there's some cool stuff coming up. So I'm looking forward to getting through some of these.
Yeah, you still have a little more time, Mike?
Yeah, I do. I've got a little more time.
Okay, so
you know what? I blocked off an hour on my calendar, but knowing John, you and I knew that we were going to go probably a little bit over, so I don't have anything else for a little bit.
Yeah, good deal.
We'll get some flex time.
So let me see here if try to catch back up. And if I have skipped over your question, I apologize. We'll try to get it or just type it back in. So 2 questions. Can I have old debts that's over 15 years old removed from my credit reports? And okay, so if they're current, I mean, in other words, if they're positive accounts, there is no limit. And frankly, we don't really want positive accounts removed, even if they're very old. If they're negative, they should come off 7 years after you went delinquent that you never recovered from. And so,
unless it's a bankruptcy, which is 10 years, and certain judgments, which can last longer. And I forget the exact time length for a judgment. But yeah, if it's just the account and it's, well, the way this is worded leads me to kind of ask a little bit more of a question, because it depends on that date of first delinquency, right? So you might have opened the account 20 years ago, but you missed your first payment 2 years ago. That's going to stay on. If the non-payment is more than 7 years ago, then it should be coming off. With the caveat, of course, that, again, I'm always adding these little wrinkles and things, right? If you've brought it current at any time since then the date of first delinquency actually is after, the first missed payment after you brought it current.
Yeah, and that's a really important point. This date of first delinquency, that's a starting point where you miss and you never bring it current. So if on my Discover credit card, if 8 years ago I was 30 days late and then the next month I brought it current, well, that can still be on my credit report. Date of first delinquency is when you go delinquent and you never bring it back. Okay. So let's see here.
Well, and then she also asked, what do I need to do?
Oh, yeah.
And I want just to be clear, that is something you should say, dispute in writing to the credit reporting agencies and say, this debt is more than 7 years old, please delete it. And if they don't do that, then as John said earlier, they're inviting you to sue them because you're suffering from damages from the violation. If you've got the damages from that. So that's right. Just wrapping that up.
Yeah. So here's Steve. Mike, do you do anything with original credit harassment? I can answer that for Mike. Yes, he does.
Well, I want to take advantage of this question because, first of all, Steve, if you've got issues with collection of debts, original credit or otherwise, we're in Pasco County. You probably already know where Dade City is. So do give us a call. It's 352-567-3173. You can look me up. You can punch through to my YouTube channel. I've got click to call links everywhere. And certainly I'd be more than happy to talk to you. But I want to touch on original credit harassment because when people talk about being harassed by folks who are trying to collect debt, what you think is harassment and what the law thinks is harassment may not be the same thing. You can be really frustrated. You can be irritated. You can feel very aggrieved. But harassment is a fairly fluid thing. And it's the bar is a lot higher than most people think because inherent in any debt collection, original credit or otherwise, is going to be some kind of emotional turmoil that you're feeling, right? Because none of us want to be, whether it's for a debt you really owe, in which case you're probably having some feelings of anxiety or shame or guilt or whatever. And if it's a debt you don't owe, then you're going to be really angry, right? There's inherent in that is going to be some. So although you're feeling harassment, we might look and see that might not be what we sue for. We might find something else that they are doing wrong. But if you're annoyed with the way somebody is trying to collect a debt from you, definitely see what you think is wrong may not be what's actually wrong. What you think is against the law may not be what's actually against the law. But your lawyer should be able to work through that with you. So I'd be more than happy to talk to you. I think my first appointments are going to be early next week after the holiday. But I would be delighted to talk to you and anybody in Florida for that matter, but particularly in Pasco County. So.
Yeah, and two things following up on that. What Mike said about sometimes we think something is illegal, it might actually be legal. Right. But the reverse is true. Sometimes we say, oh, well, I assume that debt collector can call my ex-mother-in-law and say, hey, get John Watts to call us, about this debt. Well, people may assume that that's fine. I look at that and say, that's a 6-figure FDCPA case. We're going to just blister somebody for doing that. Okay?
Depends on the mother-in-law. But yeah.
Well, ex-mother-in-law, probably not a great relationship, but that's sort of the ultimate insult, right? Is they, not only are they harassing you, but then they call your ex-mother-in-law and she's like, I knew my daughter shouldn't have married that loser. So, but the second thing is, Steve, you're there in Pasco County, and Mike, let me just make sure. I know with foreclosures, you guys covered the whole state. I mean, you still do that, right? If somebody's in Miami or if they're in Pensacola or Orlando or wherever, you help them.
We do debt defense, foreclosure defense all over the state, and if somebody's got a debt collection violation here anywhere in Florida, we can also pursue that.
Okay, very good.
We're licensed throughout the state of Florida, Pensacola to Key West.
Big state. So here's Built by Vic. Does annual credit report update your reports every week or every 30 days? Thank you. So it's a great question. It's really, when do the furnishers, and they're called furnishers because they provide or furnish information to the credit bureaus, when they do that. So if you pulled your credit report this week and then you pulled it next week, there might be nothing changed, or there might be all items changed. Okay, because it all depends on when Capital One updates, when Midland updates, when Bank of America updates. So annual credit report's really just the portal to then go to Equifax, Experian, TransUnion, and they update really as soon as they get the information. So we see some debt collectors. Sometimes I see portfolio recovery update once a week, but the rule is, if you're going to provide information about somebody, unless the account is closed, then it's at least every 30 days it has to be updated. And the bureaus there may be a slight lag, but they're going to update it as soon as they get it. At least that's their intention. Let's see here, Mike, we've got a deficiency. So Mercedes-Benz is requesting deficiency after refusing to give me information on the date, time, and address of the sale. The auction car was sold for $10,000. So let me describe how this works in Alabama, and then I'm curious if Florida is the same or different, or does it depend? So what we're talking about is, you get your car repoed. Let's say you owe $20,000. They sell it for $5,000. Well, then there would be a deficiency of $15,000. Well, if they don't tell you where it's going to be held, or at least the time, if they don't send you a certain letter before the repo sale, after the repo sale, then we can have some defenses to it. It's not automatically that they lose their right to collect. There are some states where they mess up these letters, sort of visualize a timeline.
Repo debt collection. And so what's interesting about this is that this is usually part of the Uniform Commercial Code governing secured transactions. Anyone who's gone to law school, law across the country, but each state does actually have a different version of the UCC it's passed. So in Florida, when an asset is seized, that's used as security for a loan. So you have a car loan, your car, they are required to give you notice prior to the sale. And then after the sale, they should be giving you the information about what the sale happened. Now, if you're looking at where they are refusing to give you information about the sale when it's held, if they sue you if they were to sue you in Florida, I would say, all right, well, failure to provide fail to provide notice of a commercially reasonable sale is potentially a defense to that debt collection. And so that might be a defense I would raise in the action. But prior to going to court, I'm not sure that you have if you're just calling up Mercedes-Benz and saying, well, when did you sell the car? I'm not sure that you have a current right to request that. Even if you did, what it would get you. But if you were in court and you say, well, hey, you were supposed to notify me of the sale and you didn't do so, you may be, and part of that's because you have a right to go and make sure that the sale is fair, right? Because if your car is worth $50,000 and sells for $2,000, you might have a legitimate suspicion that maybe they didn't advertise it as well as they should have, right? But you might want to go bid on it. And so, you're entitled to pre-sale notice and you're entitled to some disclosure about afterwards. But I don't know that barring a court action, you'd have any meaningful way to prevent that from happening. Although also too in Florida, because of the way our debt collection statute is worded, if you have a creditor who is pursuing you for that deficiency when they haven't complied with all those requirements, they are asserting a right they don't have, which is to collect money from you, and you can sue them and put money in your pocket instead of the other way around. So there's all kinds of really interesting wrinkles with all this stuff. Here I go again, throwing more wrinkles at things. I might want a sponsorship from Oil of Olay or something, and get the wrinkles out. But there's a lot of different factors at play in something like that, and it's going to depend on your state and how they have interpreted or implemented the Uniform Commercial Code governing sale of collateral for secured debt, which is the car.
Very good, very good.
I hope that was clear. It didn't sound too clear from this end. I hope it was more clear.
But the only thing I'll add to that is, oftentimes under the UCC, again, even though it's uniform, it does vary. Ironically, you may have a right to send a letter. Just check the UCC. Sometimes it'll say you can write a letter requesting some of this stuff. But here's so Laura was asking about identity IQ. And so here's Shadow Smurf saying they're a great tool, but check your actual reports, see the same discrepancies, dispute. And so, identity IQ, Credit Karma, Smart Credit, all those things are tools. And sometimes we can't get our real reports, or maybe we're delayed getting them. So definitely use the tools, but never confuse those tools with your real reports. I think the video I put up Saturday was a case decision where you see a judge like hammering that point home about, yeah, it's cute that you have your Credit Karma. That ain't your real report. So you lose. Okay. So we really do need ultimately our real reports here. And let's see. The statute of limitation.
It's a better question than it may look like even.
Yeah. Yeah. The statute of limitation apply to a state you live in or a state where a debt was incurred. So I'll give you at least a partial answer. So this is what we learned in law school. There's this thing called the Erie Doctrine. You remember that case, the Erie Railroad case? So it basically said
more flashbacks.
We may need some therapy after this, Mike. But it basically says there are procedural laws and then substantive laws. And I'm going back to 1992 when I'm saying this, but procedural laws often, but not always, are statute of limitation. In procedural laws, we use the procedural laws of the forum state. In other words, where you're sued. So let's say that I want to sue FedEx, and I want to sue them in Florida. Well, they're based in Tennessee. I live in Alabama. So which rules of civil procedure are we going to use? It's not Alabama rules of civil procedure. We're going to use Florida rules of civil procedure.
Or
so typically, well, if I sue in Florida.
Yeah. Oh, if you sue in Florida, right.
Yeah.
Okay.
And so here's a real life example. It's a terrible situation, but we sued a trucking company in a wrongful death case. The crash happened in Tennessee. They were a Georgia company. We sued them in Alabama. So Alabama rules of civil procedure applied, but the substantive law, okay? In other words, what do you get from a wrongful death? Because Alabama is real unique. We only give punitive damages for wrongful death. And every other state, we look at the life expectancy and the amount of lost income and the effect on the family. In Alabama, we don't do that. It's very strange. But we grabbed that law from Tennessee and said the substantive law of Tennessee applies even though the suit was in Alabama. So that's a long way of saying it can get complicated. And then you bring in the wrinkle that Mike added, which is sometimes in the contract, it says, we all agree we're using South Dakota law, Virginia law, Delaware law. So does that bring in the procedural law and is statute of limitations procedural? So it's a great, simple question that unfortunately has sort of a convoluted answer, which I say all that to say it depends.
Yeah. And I'm going to add as always, a couple more wrinkles to it. So Florida has what's called a borrowing statute, which says effectively that if the laws of another state would bar a claim based on a passage of time, then it won't fly in Florida either. So basically, Florida will say, if there's a shorter statute of limitations in another state that would operate to bar it there. So if you have a defendant in Florida and a plaintiff in, let's say Virginia, right? And Virginia has, let's call a 4-year statute. Florida is a 5-year statute. Florida will actually say, well, wait a minute, it'd be 5 years here, but if you can't sue in Virginia, we're not going to let you come down here and sue to avoid the Virginia statute. And there's some other case law that talks about some other circumstances where Florida might reach out and borrow statutes of limitation from other places, depending on, like if you've got the car accident in Tennessee, Florida might actually say, you know what, we're going to look to Tennessee law, especially if it's shorter. We're going to look to Tennessee law to see if the statute of limitation bars it. It's really it's a weird. The more you look at that area of law, the weirder it gets. So it is a very complicated way of saying it depends.
Yeah, and actually the Erie case, which this was a famous case from, I don't know, 200 years ago or longer, it involved the person where they lived, the statute of limitation had expired. They couldn't sue there. So they went to another state where they could sue that had a longer statute of limitation. So we see this in mass torts where, there's a defective product, a drug. Maybe in my state, I would be barred by a statute of limitation, but I'll go file it in, I'm just making this up, Utah or, Wyoming or something. And that has a better statute of limitation. So it does get a little bit complicated. Great question, though. So here's Laura. This going back to how do we do disputes? I'd also attach credit reports as well. This is a great point about making the information easy to see. So I was just talking to a guy from Massachusetts who he sort of drops in sort of a little grid of the payment history and points out the discrepancies. I tend to not do that. I just say, hey, June 2018, you three bureaus have different information. Other people will put a screenshot of the actual credit report. They when I say a screenshot, like a little snippet, they just drop that in there. You can attach the credit reports and circle them. But what you said, Laura, right here about presentation of information so it's easy to see, that's really critical because, and Mike mentioned this, when we sue under the Fair Credit Reporting Act, those dispute letters become exhibits. The judge is going to read that dispute letter. I prefer that the judge can read the dispute letter. Everything is self-contained, okay? They don't have to say, oh, well, let me go now look through a 58-page credit report. I've said it all in there. And so I want the judge, when she gets done reading that letter, to look to Equifax, Experian, TransUnion and say, guys, it's pretty simple. What are you doing? Why didn't you fix this? And then when they go, oh, well, it was too long. It was more than one page. And, of course, if you send a one-page one, they say, well, it's too short. You didn't give us enough information. They're going to criticize you, whatever you do. So you just do it in a way that would be easy for a judge to see that these are legitimate disputes, actual errors, or incomplete. And then you want the judge to say, so boys, what'd you do in response to this letter? And then watch the bureaus start to sputter and stutter. So that's my thought on that. Let's see. Here's a question. Can a charge-off change to a closed collection? So that's an interesting question. As long as an account is still active, it can be reported every month as a charge-off. But if they do close it and say, all right, this is closed, then yeah, it could be changed to that. Now, again, normally we think of collection as with a third-party collector. So it would depend on exactly what we're talking about here. But the bottom line to any credit reporting is we look at it and say, is this accurate? Is this truthful? If it is a closed collection account, then that would be truthful. If it was charged off, now it's closed, then again, you just want to ask, is it truthful? And there may be a follow-up to this, Mike.
Yeah, this is something I was noticing as well. So it's really interesting.
Yeah. So why don't you take this one, Mike?
So one of the things I see a lot is that people get a lot confused between the statute of limitations for being sued, which is court action, versus the time limit for something to be reported on your credit report, which is credit reporting. So those are two, what I call the three buckets of debt collection. That's two of the three. And so if you're saying my statute of limitations is 4 years, okay, that is a limit on the time that a debt collector has to file a lawsuit against you. And then the question is, can a debt collector show as open and continue to try to collect? Well, it might show on your credit report as open, as an unpaid open account that is still pending, because that's the 7-year limit that we talked about earlier. And then continue to try to collect, or is there a violation? So that's a very interesting question, and the answer is I would really like to see exactly what is being said, because if a debt collector is communicating with you, that's the third bucket, right? If a debt collector is communicating with you and asking you to pay a debt, and they fail to disclose that it's beyond the statute or maybe time barred, then that can be a violation of federal and state debt collection law, because they might be giving you the false impression that they can sue you, even though they really legally shouldn't be doing so. And in fact, this is one of the things that Midland did wrong. Midland was recently sued, I think it was last year, by the FDCP, by the Consumer Finance Protection Bureau, rather. And John and I actually both have videos on that. And we went through the lawsuit, and that was one of the allegations, that they were suing people after the statute of limitations had run, and they were trying to collect after the statute of limitations had run, and that was deemed to be unfair. What's interesting is that you actually can sue even after the statute's run, because the statute of limitations in every state that I'm aware of is waivable. So if your debt is 20 years old and somebody sues you and you just forget to mention statute of limitations, that suit can go forward. But that almost never happens. But what you have here is, if a debt collector is communicating with you and failing to disclose that age issue, they may be violating the law. They can still report on your credit report. They can try to bring you to court, and if you defend with the statute of limitations, they'll get thrown out. But if they communicate with you without that disclosure, that can be a violation of the law.
Yeah, and just one thing to add to that. So the FDCPA does not expressly say suing or threatening to sue after statute of limitation violates the FDCPA. There's actually a sort of famous judge in Montgomery, Alabama, federal judge, who looked at this and said, it's called the Kimber case, probably 30 years ago now, and said, hey, this violates the FDCPA. And then other judges said, yeah, you're right about that. And so take Mike's example, 20-year-old debt, way beyond statute of limitations. They sue you. You might lose if you don't raise the defense, but you can still sue that collector. I mean, they got a judgment against you. You go get a judgment against them. Okay. So you always want to raise that as a defense, because as Mike said, if you don't raise it, it's waivable. You can lose it. You don't get to bring it up at trial. Yeah. So here's, let's see, this is back on the utility. So Entergy in New Orleans. Okay. And she's saying she never allowed it as like a credit boost. They just slapped the account on as a charge off. So yeah, that's interesting, Brandy. I would, if I was in your situation, I would challenge the accuracy and completeness of that reporting to say, well, where's all my positive payment history? And there was a recent discussion of this, maybe with business credit, how in a lot of business credit contexts, they don't report anything until you get late. So like the only reporting you have is negative reporting, which doesn't paint an accurate picture. But that's what I would do is look and see, if they say, excuse me, if they say you opened your account, 5 years ago, and now it's a charge off, I'd say, well, where's the 5 years of payment history? Now, if they say, well, you just opened it, last month when it was charged off, well, that's not accurate. So we're challenging them on accuracy and completeness on that. So here's one. Tell me, Mike, in Florida, if a process server tapes the summons and complaint on the front door to your home, is that proper service?
There are some limited circumstances where service by so-called posting, which is what this is allowed. Usually it's limited to landlord tenant, things like that.
Right.
Now, I'd be curious to see what the process server would do on the return of service. Do they claim they actually gave it to a person, or did they admit in their written report, did they admit that they only posted it? But again, one thing we've discussed is that service of process laws vary from state to state, and so in Florida there are limited circumstances where that would be allowed. But I would be really curious to see the circumstances of that. If it were, let's say it were a small claims, debt suit or even a foreclosure case, right? I would probably be challenging that. But I'd really love to see a fact pattern where, the process server claims to have served the person on, Monday, June 1st at 10 a.m., but you're coming in and say, well, actually I was at work that, at 10 a.m. and here's my time cards to prove it, something like that. Because if you can prove you were somewhere else, then you couldn't have been served at home, unless it's one of those limited types of cases where posting is allowed. How about you, John?
Yeah, we're the same in Alabama, basically landlord tenant, which kind of makes sense. I mean,
Right.
if I'm in an apartment, they post a notice on my door, that ought to be great notice to me. But I'm not aware of it in any other context. I had so we don't have the good statute you have against original creditors, but we do have just some sort of generic invasion of privacy and things.
Right.
I had an original creditor. It's one of these little loan shark brick and mortar places. And they wrote a letter to my guy saying, you owe $250 and you better pay it. We're coming after you. And they taped it to his door, his apartment complex, and every door on the floor. and so it's like, apartment, 20A. Well, they put it on 20B, C, D, E, F. And it obviously, they knew they put it on the wrong. So we sued them for that, even though we don't have good law. I'm like, that's so bad. And, so, but in terms of process, service of process, that would only be good really with landlord tenant. So let's see. Somebody's dealing with Zwicker and Associates, which is a national collection firm regarding Amex account. I was calling to dispute it. She told me they were going to sue me unless I whip out my wallet. Okay. Mm-hmm. So the first question would be, is this a consumer account? If it's a American Express, it could be, but it might be a business account. If it's a business account, the FDCPA does not apply. If it's a consumer account and you disputed it, if you were able to get that out, hey, I dispute this account, check your credit report when they update, see if they mark it as disputed. And saying they're going to sue you unless you pay right then. If they don't sue you, assuming you didn't pay, if they don't sue you right away, then I would look at that may be an FDCPA violation as well. That Mike has referenced this when they threaten to do something, either they have no legal right to do or no intention to do. And so I would definitely look at that. Mike, do you see Zwicker and Associates in Florida? Do they actually file cases or do they just send them to the law firms in Florida?
There is one law firm I've dealt with Amex, and I don't believe it's Zwicker. I'd have to look it up. It's been a while since I talked to them, but Amex usually hires fairly, I would say, aggressive lawyers, in my experience.
Yeah, and here's some follow up.
Unbelievable.
Yeah, it really is. I mean, that it's made me feel terrible. And this is the irony is a lot of times law firms, when you call they'll call them maybe a paralegal. It's really their collection department. Sometimes the law firms are worse than the normal collection agencies. A lot of the major collection agencies, they have such advanced technology. It's sort of like AI is listening to your call. And if there are certain trigger words that are said, it'll immediately take the phone call away from that representative, give it to a supervisor. Like if there's profanity, if there's a racial term, if there's some, insulting term. But ironically, a lot of these collection law firms, it's like the wild, wild west. I mean, so I definitely understand why they would, why you would feel terrible after that. And I would get with a lawyer in your state to see, did they cross the line, and was that illegal there? Let's see here. Here's a question for you. Can you be arrested and held in jail before being personally served? Make your bail over $35,000 on civil contempt. I'm not real up on civil contempt, Mike. Are you?
Yeah, I would say that this sounds like a very, very unusual type of case. And, arrested and held in jail for what? I mean, for violating a court order that you never got notice of. I mean, I would think that if that happened, you'd have some pretty good defenses or ways to get out. Bail over $35,000. That tells me that's probably a criminal charge of some reasonable severity. I mean, $35,000 is a big chunk of change for something that, civil contempt, like that. Like in Florida, that doesn't all line up. Like if you have a criminal contempt because you failed to do something, obey a court order, you'd have to have knowledge of it. There's a whole host of other limitations on the court's power to impose contempt findings. And I very rarely deal with that. I would only see it in the context of, if you violate a court order intentionally, and it would have to be pretty serious. The one time I've seen somebody brought into custody for civil contempt is where I happened to be in the courtroom when a family law docket was going on, and this poor bastard dropped the F-bomb at the judge, and he got a 45-day vacation. Do not pass go. So that was not a smart thing for him to do. But that's, my experience with contempt is pretty limited. So I don't know. This sounds like a very unusual case, and the stakes are that high. It's probably a really, really good idea to call to involve a lawyer in your state who's familiar with the particular judge involved, and see if there's something that can be done there, because that seems like a very, very unusual and extreme fact pattern.
Yeah, definitely. So here we have the CFPB will not hold the credit reporting agencies accountable. And this is a follow-up. They actually support when a debt buyer says, do you have any evidence you can give us, right after the debt buyer hasn't providing documentation. So here's the thing to keep in mind. The CFPB is a tool, okay? And you can use the CFPB when it's useful, but never make the mistake, and I'm not saying you have, but a lot of people make the mistake of thinking, well, the CFPB is my savior. They're going to, right all wrongs by debt collectors and credit bureaus, and they're just not going to do that. Now, during Obama, they were more aggressive. During Trump, they were less aggressive. Now under Biden, they're becoming more aggressive against companies. And depending on your philosophical point of view, that can be good or bad. But I'll just give you an example. When COVID hit, and I still hear people make this mistake. They absolutely get this wrong. When COVID hit, the CFPB came out and said to the credit bureaus, hey guys, we know this is a crazy time. If you're doing your best and you don't get disputes resolved within 30 days, we're not going to take regulatory action against you. Well, so many people, and I've heard them stand on stages and say this and say, the CFPB gave immunity to the credit bureaus. They don't have to respond to your disputes. They can take as long as they want, never respond. And I think I put a video up when this first came out, and the gist of the video, this is March of last year, was I ain't the CFPB. Okay. I didn't make that promise to the bureaus. Okay. I'm not regulating the bureaus. I'm suing the bureaus under the Fair Credit Reporting Act. There is no extension of time for them because of COVID. So just understand the CFPB, depending on who's running it and which lawyers are involved. I mean, sometimes they do things that we kind of scratch our heads of, like the deal with Midland. You know, it looks like they're trying to just devastate Midland, and then they, I don't know, find them $100,000 or something silly like that. And so you can use them when they help you, but you always have to protect yourself. You have to handle this on your own.
I think the important thing to remember is that the CFPB is designed to address systemic, global kind of problems. They're not built to, they're not equipped to, they're not empowered to address your problem unless it's part of a really, really pervasive pattern. That's why all these consumer laws exist that allow private attorneys to step in on your behalf so that your individual problem can be addressed by a lawsuit in your case. The CFPB exists not to be your savior, but to be the savior of the system and the fairness that's supposed to be found in the system as a whole.
Yeah, very good. So I'm looking at the time here, and I think we need to let's try to go through the questions quickly. I realize we're like way behind on these questions, but we'll wrap this up pretty soon.
You're about to skip over Golden Gate, and I want to address that one if we can.
Yeah. So definitely. So what can someone do who's been sued by a debt collector, doesn't have the money to hire a lawyer? So why don't you give your quick suggestions, and I'll do the same.
Sure.
Right?
Well, first of all, this is something we actually talked about on Monday, which is that, in Florida, if you lose that suit, you can have a quarter of your paycheck disappear until the debt's paid off. So if you can't afford that, then a lawyer is almost always going to be cheaper, depending on the size of the debt too. And so that's going to be one thing. The other thing is that, remember all these violations we talk about. If there are violations in your case that can generate money for you, if the debt collector's done something wrong that they can be sued for, that might be something that we are interested in taking on a contingent basis. That's something that we can take because the other side's going to pay us our fees at the end of the day. So just first of all, never assume you can't afford an attorney. If you've talked to one attorney or two attorneys that you can't afford, keep calling until you find one who you can. And number two is it's possible that your case may have some kind of violations in it that fund the defense, so to speak. So just think of that.
Yeah, I agree with all that. And then the other thing is, you can talk to lawyers, whether it's me, Mike, whoever, and there are resources that we put out to help you do this on your own. Mm-hmm. And so, because sometimes the option is, I don't have any money. I'm just like, if I don't have it, I don't have it. There's maybe no violation. And so you may have no choice but to represent yourself. And then you want to do that in the best possible way. So, we have videos about like mistakes people make when testifying. How does the process work? I know Mike's done a video like that. I've done a video like that, sort of start to finish, just so you know sort of what you're getting into. And but the thing I'll stress is don't assume. Make sure that you have checked with some attorneys, and there may be some creative way to do it. In other words, well, maybe it's $2,000 to defend you in this case. I don't have the money, but looking at your credit report, there are violations that are going to generate more than $2,000 to you. Well, the lawyer may be able to work with you on that. So let's see here. Thank you for everything y'all do to help people. Well, you're very welcome, and thank you for being here. And there's our good friend Cedric. So thank you. And let's see. CR said, same experience. I want you to submit documents you're requesting creditors who refuse to give it. Advise CFPB doesn't get involved, get an attorney. Yeah, I mean, you get caught sort of in this loop of give me the documents, but I can't get the documents, but I got to. So again, you can make a complaint with CFPB, but never rely on that. Let's see. David says, if you ask for debt verification from a collection agency, how long do you wait for a response before I send cease and desist? So real quick, debt verification, validation, I call it request for information, which Mike will recognize from our world of what's called RUSPA, dealing with mortgages. But that's what it is. We're requesting information from that debt collector, maybe contract, monthly statements, whatever. I would give them probably 30, 45 days. There's no set time for them to respond. But you can set up just in your own mind, say, well, if they don't respond by this time, I'll send them a cease and desist. If they send you what's called 1692G letter that says you have 30 days to dispute, to request validation. If you request in that time period, there still is no time period for them to respond. They just can't collect until they respond. But they generally do it within 30 days. So that would be a reasonable time. Give them a little mail time, the things crossing in the mail. Maybe you say 40 days or 6 weeks or something, but that would be my thought. How about you, Mike?
Yeah, I mean, I agree that there is no specific timeline. And if you are doing that verification request in response to that 1692G letter, then yeah, you have 30 days to send yours, but then they have, they just don't get to collect until they do respond. So really, I guess it's going to depend on what you're looking to do and what your objective is. If your objective is to stop harassment or stop communications because they're annoying you, you can do that. One other thing you can do, and we touched on this earlier, is if you do have a lawyer who is willing to put themselves between you and the debt collector, then you can say, well, listen, I want debt verification. Send it to my lawyer, right? Here's my lawyer's contact information. Or have your lawyer say, we're disputing this on behalf of David, and please send us the verification. That way you're accomplishing both there. You've got a cease and desist where they're not bothering you, but you've also set up how you can receive that verification. If you're really, because the goal of the verification really should be to gather information you need to determine whether the debt is actually yours and correct, right? And if you get that information, especially through your attorney, and they can determine this is or is not a correct debt, then they can do something about it. But you also don't necessarily want to be watching your phone ring off the hook with somebody trying to get money out of you.
Good point. So there's two questions here. From Matt. It says, after my dispute letter, TransUnion sent a letter back saying they won't investigate again, which they didn't because my address was still wrong. What's my next step? Equifax deleted. And then it says, after Equifax, my score went to 0, which I wonder if that's a typo. I mean, unless Equifax deleted everything in your report, your score wouldn't go to 0. And really, it doesn't even go to 0. It just says we can't generate a score. But going back to this first point, and this is part of why, we at my firm sort of harp on the personal information, the address, the name, like we want all that to be correct. And now normally when TransUnion says they're not going to investigate again, that's because they've already investigated within about a 90-day period, and they don't deem you to have given new information. And so sometimes we'll dispute, they won't fix it, we'll dispute again. They say, we refuse to fix this. Don't ask us again. Okay, we can accommodate you. We can sue you. And so
we'll ask in a different way.
Yeah. So I'm not sure about why the score went down that low, but again, it all comes back to what Mike and I have talked about. Do legitimate disputes, actual errors, incomplete information. If they don't fix it, you sue them. I mean, that's the bottom line.
That's one thing I see a lot of people overlooking. They're like, well, why won't they just cooperate? Because the answer is, they don't have to do anything, but if they choose not to do what they're supposed to do, you get to sue them. And if you're not prepared to sue them, be prepared for them to not want to cooperate with you, because they don't have to obey the law. They just have to obey the law if they don't want you to sue.
Right. It's your only leverage over them. Yeah, they don't have a meltdown because you send a certified mail letter. They get, they have a meltdown when you sue them. So here's something from Jim. He says, I have an arbitration award against a debt buyer. So that's very interesting. Tennessee federal court refused twice to confirm the arbitration. How do I get the award confirmed so I can collect on it and overturn the local judgment? So, Jim, I'm going to make some guesses here, and I may be totally wrong, and you can tell me, and I realize you put this comment up quite a while ago, but here's what has happened sometimes. A debt collector sues you, gets a judgment, and then the consumer ends up doing, in essence, a bogus arbitration against the company. It's like my buddy down the street's going to be the arbitrator. And then he issues an award for $10,000 and judgment goes away. And federal judge looks at that and says, that's not a real arbitration. There are companies out there that are sort of selling these fake arbitration awards. And companies used to do this against consumers, and those have been shut down. They've been prosecuted. But we still see some of these. I'm not saying that's what you have. I don't know. But the two legitimate places are AAA and JAMS, JAMS. If your arbitration award is not from one of those places, I would be very skeptical. And that's probably why the federal judge is saying, I'm not interested. Plus, if the arbitration award says the state court judgment is no good, well, the arbitrator has no power to do that. Only the state judge can say, my judgment's no good. So if the sequence is state court judgment against you, you then get an arbitration award that says the judgment's no good, well, that's worthless. And then you go to federal court, federal judge is going to say, yeah, this is no good. So that would be my question for you, Jim, is where did you get that arbitration award from? Which organization?
Arbitrators are us.
Yeah. And look, if
it's legit, then what I'd want to know is if the judge twice refused to confirm it. I'm pretty sure the judge spelled out in detail why that's the case, and I'm guessing that Jim knows exactly what's going on in the judge's mind, because the judge probably set it forth in the, so Jim probably knows either what he has to do to get it confirmed, or he probably has an idea that this judge has determined that this award should not be confirmed for whatever reason. And so, how do I get it confirmed? Well, I'm sure the judge has told you what you need to do if it's possible at all. Yeah,
and here's the other alternative. The federal judge is just wrong. And it should be confirmed.
Oh, that never happens. Come on. Come on, John.
And then you appeal, because there is definitely a bias in the court systems to respect arbitration. So this is very, very unusual. And Jim, I would just like to know a little bit more information. And like Mike said, probably that order spells it out, and either challenge that order by appealing it. I think that's the Sixth Circuit is over Tennessee, or see if he gives you a roadmap about how to fix this.
Yeah.
So let's see here. So Steve said he'll give you a call, Mike. So that's great. And go back to our Zwicker and Associates. You record the call. I would just make sure that was appropriate. Now, even if it wasn't, don't destroy it, because that's evidence. Okay, we don't ever destroy evidence, but I would take that recording to a lawyer in your state that sues debt collectors and see what happens here. This back to that Mercedes-Benz deficiency. There's arbitration in the fine print. Look, arbitration is designed to hurt consumers, but we can turn it the other way. I did a webinar last week on using arbitration against, for example, cable companies. And we can use it against credit card companies, cell phone companies, all sorts of things. So we can turn it to our advantage. And you just need to see what the rules are. Again, it should be AAA or JAMS. And then see if it would be something that would be worthwhile to do that. So let's see. John says, I got a good one for you guys. Well, we are always interested in that.
It's a little further down, but I see Shadow Smurf here is correctly pegged Article 9 as being the Uniform Commercial Code section that
Yeah.
deals with the sale of secured collateral. So clearly we're dealing with either a law student or a lawyer or somebody who may have been through this particular ringer before themselves. So
Yeah, again, saying the words Article 9 and UCC, that most lawyers kind of start, tremoring and
breaking out in hives.
It was in that class that most of us had this thought of, why did I ever think I could make it through law school?
I took UCC as a summer class, and I never in my life thought I'd be spending all of my days litigating, UCC issues, which I do.
Yeah. So let's see here. Ronald says there's extra incorrect info on my address on my Equifax report. I dispute it, sent a copy of my ID. They still won't remove it because it said wrong address was verified as mine. How can I fix it? So,
got to sue.
Yeah, I'm assuming your ID has your correct address. Sometimes you can do like, here's my tax return, but usually, if you have your ID, maybe a utility bill, and they won't fix it. I mean, what your address is. And if they are verifying false information, then I would sue for that.
And you want to get that removed, because if they have a debt account linked to that wrong address, they might wrongly use that address to verify a debt that's not yours.
Yeah, and it's sort of this circle of, they might not even give you your credit report because they ask you a question about an address and you say, that's not my address. And they go, you got that one wrong, Mike. So we're not giving you your report. So that's why we want to clean up all this personal stuff. Let's see. CR says, can credit monitoring from the credit bureaus be admissible evidence?
Oof.
So here's the short answer is Equifax can tell you what Equifax is reporting. Equifax, when they start telling you what TransUnion and Experian are reporting, now we're getting into, and this is not technically the 100% precise definition, but we're getting into hearsay, okay? Because this is what Equifax is saying, somebody else is saying. And so you really, really need it to be directly from each bureau, okay?
Now, one thing I will say, because I agree with that, you want to go direct to the source for what your actual report is. But if you're trying to prove that a disclosure was made that was incorrect, the fact it's on your credit monitor service can be evidence that the disclosure was made. It's still, if you're not trying to prove it's correct, it's not technically hearsay. If you're just trying to say, listen, I mean, they're lying about me, and here's how we know, because this statement appeared here. So there are some limited circumstances where that might be admissible, but boy, is that a nightmare trying to jump through to lay that like if you want to try and lay the foundation to convince a judge it's admissible, that's going to be kind of a tough slog. I'd really much rather see the original report.
Yeah, and so let me just take a moment, step back. So hearsay is any out-of-court statement that is offered to prove the truth of the matter asserted. So, it doesn't have to be, well, Jack said that Bob said that Susie said. I mean, it can be Jack saying, well, this is what I said. That can be hearsay, even though he's saying it himself. And when I'm using hearsay in this example, I'm sort of using it in the just the common expression of it that, Equifax is saying, well, this is what Experian saying. It's more of, can they authenticate those documents as being accurate? And like Mike said, there are ways to do this with credit monitoring, but you've just added, it's like, can I go from Birmingham, Alabama to Tampa via New York City? Well, yes, I can drive my car from Birmingham to New York down to Tampa. There's a whole lot easier ways and better ways to get there. Okay. So,
and one thing I'll add to that is that kind of, and I know John does this too, but we both live and die by understanding how hearsay works, how the evidence code works. And I will tell you, I've run into cases where, judges didn't agree on some of the most basic definitions of what hearsay was. So it can be really weird getting things in unless they meet a very precise set of expectations. that the judge has. And so it's just much, much simpler to do it the way the judge will expect it and is interested in hearing.
So here's John said, my car was stolen. Car was fully covered. There was a deductible, $1,000. They told me I had to wait for insurance to pay before they would accept the deductible. So the insurance paid, deductible sent, took them 2 months to pay the car. They said, oh, 2 months because I was liable till the car is paid in full. So I've had cases like this where what you have to do is show that either the car company is at fault. So some of mine have been gap insurance, which is literally to cover that gap between what you owe, what the car's worth. And maybe the finance company improperly fills out the gap insurance request. Well, that's on them. Here, you tried to pay them the deductible. They said, nope, you wait till the insurance pays. And then it took, a while for the insurance to be paid. This is something where I very rarely talk about this, but under the FCRA, I always talk about it's inaccurate or it's incomplete. There's actually a third version, which is it's technically accurate, but yet it is misleading. So it might be technically accurate to say you were 2 months late because you didn't pay for 2 months, but that's misleading because it makes it look like you're not paying. And so, John, what I would do on that is dispute it, lay it out in very clear detail, very vivid, about here's exactly what happened. And, if you've got emails, if you've got dates, times for phone calls, everything, sort of lay that out. The gap insurance case I'm thinking about, our dispute letter is one account. Our dispute letter, not any attachments, just the letter itself, I think was 12 pages long. And the reason it was so detailed is it's going through and saying, and then I called this person at the finance company and they transferred me here. And then I waited 3 days. You never called me back. And then we laid it all out. They verified it. We sued them. And, we were very happy. Just put it to you that way. So never be afraid of like incredibly detailed disputes. And it drives me crazy when I'll see these self-proclaimed gurus who don't know what they're talking about going, never have a letter over 2 pages long. No, if it needs to be 12 pages, make it 12 pages long. And, you can really get some good results. Either get it fixed or it's now properly arranged so that you can sue and get justice.
And also, remember that that's going to be something that a judge or a jury is going to see. And if they see that you took very detailed notes and kept really good records, and you establish that time and time again, you try to get them to do the right thing, and then time again, they refused, that's going to make an impression.
Yeah, definitely. So let's see here. Can you show an example how a collection account should be reported accurately? Well, if you've disputed it, under the remarks that something like disputes the account. Otherwise, as far as how it's accurate, they just need to be correct. So let's say Mike beats Midland Credit Management in Florida and he wins. And the next month they show it as being owed. It's not owed.
That's right.
They can't show it as zero because he doesn't owe anything. So there shouldn't be anything on there at all. Let's see. So yeah, Erie versus Tompkins. That's right.
Yeah, Shadow Smurf once again whipping out the law knowledge.
That's right. 100 years ago. Yeah, I was thinking it was longer ago than that. It was actually 100 years ago that I was in law school. I think that's what it was.
That's exactly right.
I remember when Erie came out, like we watched it being argued, apparently.
That's right.
So very good.
Shadow Smurf says elsewhere that he's not a law student. He just reads a lot of law books or listens to law books online. So
yeah, he's
that's really interesting.
Guy. Yeah.
So
can a creditor report delinquency on your report after 90 days? Can you be 120, 150, 180 past due and be reported charge off every month? Yes, you can be reported as a charge off every month. Charge off is just that's the status for that particular month. The account's charged off. So you could have 20 of those in a row. And again, we just take them and say, is this accurate? So if it says 90 days, well, were you 90 days late? And if you were, that's fine. If you're not, then it's incorrect. Let's see here. So we've got Muriel. She often appears. So good to see you, Muriel. And
Muriel's comments on some videos too. So yeah.
Yeah. So if I tell a debt collector I refuse to pay, what happens? Well, if you tell them in writing, that's the same thing as a cease communications.
Mm-hmm.
So that's section 1692C, and then it's little in parentheses C. So it's CC. And if they call you or write you with very few exceptions after that, then you could sue. So Mike, our foreclosure expert, said a foreclosure 2019 USDA loan answered the summons. So this must be a judicial foreclosure state. And right before the pandemic, judge canceled the case. I had a release of lien, satisfaction of mortgage. Now it's on my credit report. And is there any? Yeah, okay.
And I saw there was some other a further follow up there. In which way would it dispute that in the credit? So first of all, I want to make a point here that when USDA loans during the pandemic were going to be covered, there's some CARES Act regulation. There are some reporting regulations that apply to them. If this cancellation of the lien, the release of lien and satisfaction of mortgage occurred before that, then the CARES Act issues might not apply. If it was a result of CARES Acts, some kind of accommodation, and it shouldn't be reported, that's an analysis that can be done. But what I think is happening here, I'm not sure why a judge would have canceled the case, released the lien, and satisfied the mortgage. But just because the lien is released and the mortgage is satisfied does not mean the debt has gone away. So that you most likely see that in a bankruptcy context where you'd see the reverse of that actually, where the lien survives and the debt goes away, but you still have to pay the debt to save the house. But we've seen cases. This is way back when Bank of America and other lenders got sued by the federal government for violating various legal restrictions, and they got hit with several $1 billion fine. And what they did, they were supposed to be paying that off by giving that money to consumers. So what Bank of America did, they went through their files. They said, okay, let's look at all the second mortgages we have that are underwater. And by that, I mean, like if you got like an 80-20 loan, you get 80% of the balance in the first lien and 20% in the second lien. They looked at all the 20%, the second liens that were on houses that were worth little enough that second mortgage would never be paid. And so they released a whole bunch of second mortgages, but they didn't necessarily release the debt. They just satisfied the mortgages, and they got credit for doing that against their federal government fine. So that was something. That was a weird fact pattern and all that. But just because the lien is released and the satisfaction of mortgage has been entered, I mean, that's good news for you keeping your house, but it doesn't necessarily mean that the judge has ruled your debt was paid off. I'd want to know why the judge did that, but just the fact that the debt is on your credit now, your credit report, that may be accurate unless the judge said, no, the debt's gone too. If the judge's order said that, you'll want to provide a copy of that order in your written dispute, certified mail, return receipt, et cetera, et cetera, et cetera. And so if the CRAs don't correct it after reading that order, then you might have a basis to sue, and you probably would, I would guess. I'd want to see the details of the order.
Yeah, I mean, it's a very interesting situation. I'll say this: in Alabama, if we have a satisfaction of mortgage, I can't think of any time I've seen that it does not pay off the debt. In other words, the debt's gone at that point. Now, we have non-judicial foreclosure, so this would not have been in Alabama. But what Mike's saying is definitely right. I mean, you got to pull all these documents. What I would actually do is sit down with the lawyer, whether that's Mike, whether it's me, whether it's somebody local to you, who understands credit reporting, And let's take a look at this, because let's say the mortgage is gone. Okay. The mortgage, I'm speaking in technical terms here. So the note is the debt. Okay. The mortgage is what ties the debt to the dirt. All right. The property. So yeah, I'm sure I stole that from somebody. I can't remember.
Ties the debt to the dirt. I'm going to steal that from you now.
Yeah. So. Yeah. So, what could happen is, I'll give you a different example. The first mortgage forecloses on you. Well, the second mortgage is now an unsecured debt, right? Because there's no property. The property's gone. You still owe that debt. It's an unsecured debt because the debt's not tied to the dirt anymore. So one thing you can do is, in that situation, is look at your credit report. Does it still say this is a mortgage debt? This is secured by, well, it's not. That's not accurate anymore. So you would just want to really carefully look at the judge's order, and anything filed in presumably it's probate court in your state. This release of the lien, satisfaction of the mortgage. Look at all that. Look at your real credit reports like we've been talking about. And that would be very, very interesting to see, because I suspect that should not be on your credit report, but it's the devil's in the details here. Yeah, so what exactly those orders say. Let's see here. Lawyers were contacted. No one wants to touch this. Okay, that's on.
That was the $35,000 bond for the civil contempt. Yeah.
Yeah.
A couple things could be happening here. Number one is nobody wants to take on a local judge head to head. Number two, maybe they want to charge you more than they think you can pay. Or number three, maybe they think you just don't have a very good case. Without knowing more details, it's hard to say.
Yeah. So here's one. If a bank pulls your credit report without authorization, does it matter if it's soft or hard pull? I have a bank arguing unauthorized pull is soft, therefore not a violation. Yeah, so I have very strong feelings on this. The hard pull, soft pull, that's nowhere in the Fair Credit Reporting Act. That's a function of credit scoring. So a soft credit pull does not affect our credit score. A hard pull may affect our credit score. But either they had authorization under the Fair Credit Reporting Act, or more accurately, they had a permissible purpose, okay, which is not the same thing as that you gave them permission. They may have a permissible purpose anyway, but they had no permissible purpose. I'll just tell you, my firm sues on soft credit pulls. Okay. And every now and then we get this pushback there. Well, John, it didn't affect the credit score. I don't care. I didn't see you for messing up my credit score. If I walk into Mike's house and I don't have permission, I go into his house, I go through his drawers, I go through his filing cabinets, I go through his cabinets with his dishes and everything. I don't take anything. And then he catches me and he's like, John, this is trespass. I go, but I didn't take anything, so it didn't hurt you. I'm probably leaving with a gunshot hole, because you know how those people in Florida are. They got
Florida, guns. Yeah. You're
your castle defense, stand your ground, all that stuff. So the point is, and I do remember stealing this from a guy in New York. He made this argument on an impermissible pull case, and he was there with the federal judge and the defense lawyer, and defense lawyer's like, well, it doesn't matter. It's a soft pull, no big deal. And so he said, Judge, can I ask my adversary a couple questions? He's like, sure. He goes, do you have your wallet? It's like, yeah. He goes, pull your wallet out. And judge is like, pull it out. He pulls his wallet out. He goes, open it up. Judge is like, open it up. He's like, now let's start going through it all. We're not going to steal it. And the judge is like, I get it. The motion to dismiss is denied. Okay. So I don't ever buy this junk about, well, it's soft pull versus hard pull. And the 11th Circuit ruled on this in a recent case involving bankruptcy reporting. So if you have a discharged bankruptcy debt, it should show a zero balance. The argument was, well, so what that it had a $10,000 balance? Nobody saw your credit report. And the consumer says, yeah, there are all these credit pulls. They go, those were soft pulls. And the courts, so what? Somebody saw it, So anyway, that's I would be very interested to know, more about that situation there, Russ.
But there's a fairly exhaustive, list of permissible purposes, and the statute sets out the type of things you're authorized to view it for, whether or not you've given them permission. So
Right.
there's certain things you can do, certain things you can't do, and so there definitely are. If the basis for the pull wasn't on that list, then you might have a valid claim.
Yeah, and I like those claims. I think they're good claims. So here's Muriel. My husband sent a verification to collection company and sent, I guess the collector sent back paperwork with someone else's signature and phone. We see that every now and then.
Oops.
Yeah, obviously they're not
They
supposed
just
to do
disclosed
that.
to you somebody else's debt.
Yeah.
That's not good.
So sometimes people ask me, well, can I sue? And I'm like, well, really, it's the other person that can sue. What I've always recommended is tell the company, look, obviously you have some problems. You sent me the wrong person here. And usually they will kind of, back away because they don't want you contacting that other person.
Who did you send my information to?
That's right.
That's what I want to know.
So here is our shadow Smurf. Listen to law books every day. It sinks in eventually. Well, I would say it's definitely sunk in. And let's see. Here's John. After going back and forth with the bank, I caved in and paid. They're reporting a chargeback to the credit report because I got into it with them. Okay. So
that's the car insurance claim.
Oh, okay. Yeah.
John's giving a little more detail on that.
Okay. Let's see. And that was the way to pay me back. If you look at my report, all my payments were made on time until a theft of my car. Then all of a sudden a paid chargeback. Yeah. So I would say definitely get with the lawyer on that, John, about, let's look in detail at those actual credit reports. And that is going to get into those real details of exactly what happened. And you may be able to get some help there. Let's see here. Let's see. Golden Gate says, thanks for previous answer. If mortgage company did a trial mod, then a final mod, and we're supposed to suppress the credit, but didn't, disputed with the lender in 3 bureaus, but they didn't fix it, what's next?
So if the suppression of credit was part of the modification agreement, which would surprise me, when you say they're supposed to suppress the credit, I'd be curious about the basis for that. But if they agreed to do that and then didn't do it, they've got a breach of contract problem. And so if that were happening here in Florida, for example, and Golden Gate, I recognize, you commented on some of our videos before. So I don't know if you're in Florida or not, or whether you're in California, but if there were a contract that promised to suppress credit and the other side failed to live up to that promise, I would be interested in pursuing a breach of contract action, assuming that it were otherwise viable. That would be what I would look for. I see a couple other comments Golden Gate has made, and there's a whole bunch of this is a Fannie loan, and previous mods were due to FEMA issues. So there's a whole bunch of stuff there, and if this is on a if this is on, let's see, this was on a trial mod. So I would be really curious to know what state that was in, and kind of what the basis for all this is, because there's a whole bunch of, there's really a lot of moving parts here. I'm looking at the time, it's about 4:30, so we're not going to be able to get into a lot of detail on this one, but this is a fairly complicated case, and if you're in California, I do know a foreclosure lawyer in Northern California that would probably be interested in talking to you. So you know how to reach me, and I'd be happy to send you a name for that. I'm looking. There's another. The other USDA case that Silent Citizen J had, saying Lake County, Florida. That's the one with the released lien. I don't know what's going on there, but that might be, if that's in Florida, that might be something that we could have a conversation about.
Yeah, get with Mike on that, and get him the court docs,
Yeah.
or maybe you can pull the court documents also, Mike. But
Probably, yeah.
that would be very, very interesting. Let's see. We'll go through these. Speaking of gap insurance, car was repoed, had gap extended warranty. Would that impact the amount owed? Should consumer have been eligible for a refund? Yeah, they should give you. There can be a refund of premiums, because you paid for 2 years of gap or extended warranty, and it gets repoed after 1 year. There should be some of that. And if those items are not there, I would just question the company, and you could do it sort of in a combination. You send the company a letter, and you send the credit bureaus the same letter, basically saying, hey, this is inaccurate. Here's why it's inaccurate. Give me some more information here. See, Miro, guys, my favorite. Well, thank you very much. And we appreciate all of you guys and your good questions here. So we answered both questions. Here's Jim says, does JAMS and AAA arbitrators have a nefarious nexus with the banks, credit firms? I know large corps have their own arbitrators, not fair. So I'll say this. We have had good success with JAMS and AAA. And now there was a company called NAF that was completely crooked, and Minnesota AG shut them down. I mean, it was just the most crooked thing ever. Basically, the credit card company owned the arbitration, and guess what? You always lost. Okay. So, but with JAMS and AAA, I have not noticed that. Now, obviously, everybody has their own bias. I mean, judges, some are more business oriented, consumer oriented. So arbitrators are the same, but I have not noticed a problem with that.
I'm going to steal that phrase, nefarious nexus. I'm going to use that in my next legal filing.
Yeah, there you go. So, so which law audio you listen to? So maybe that was answered here. So Mike, and I have been called a lot worse than Jim. So I've been called a lot of things that we can't print. So I will gladly answer to Jim here. Let's see.
This is more from Golden Gate.
Okay.
So yeah, most of the rest of everything looks like it's from folks we've already addressed. So I want to not. It's Silent Citizen J does have my correct phone number, so that's good. Those are the two people who really have questions left. So okay. I think this would be a great time to wrap it up. I think we've addressed pretty much everything out there.
Yeah.
And just wanted to say, John, I know that you and I both have enjoyed this quite a bit. And so we are looking forward to doing this again sometime soon. I don't know if it's going to be a couple weeks or maybe a little bit longer, and we might do it, hosted on my channel instead. And so get a different mix of people who might not have heard about this one, but we'll look forward to doing that again real soon, I hope.
Yeah, and so if you guys are not subscribed to Mike's channel, go subscribe to that, and I think I can drop that in the chat again. And we'll try to notify everybody on both of our channels when we do this again, probably in a week or two. And thank you so much for all the great questions and comments. Yeah. And thanks, Mike, for being here. And we will catch you guys soon. So have a good day.
All right. Have a good one, everybody.